Hello?
Sir, you're
Procedural
charged
matters,
with
and
especially
unfortunately you have not.
aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, he's verbose Latino.
Is that correct?
Literally not true. I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, I'm getting some weird sounds on the live stream. Not sure what that was, guys. Who was doing that? It was messing me up. Welcome back to the Court of Public Opinion. I am the Recovery Addict. It's wonderful to have you all here. I have no idea who was first in chat today. This afternoon. I just, I don't know. I just don't know.
Because we here in Canada hate you and hope for bad things for you. Because we hate you.
Yes.
I have the right to protect myself, don't I?
That is in the rule book of the laws.
That is in the rule book of the laws. All right. All the wrong buttons, but found it. Kim R161. Kim, congratulations. Everything IP-related worldwide is your responsibility for the rest of the day. The rest of the day. Congratulations, Kim. Good riddance as well. Off my shoulders and onto yours. Couldn't happen to a better person, though. Appreciate it. Appreciate it very much, Kim. All right, we are going to be going back to court momentarily. And when we do, it will be... It will be wonderful. It'll be delicious and nutritious, and it'll taste like chicken. It's gonna be everything you wanted court to be, and a bucket of wings. So, welcome. I don't know. I'm thinking about food still, and I just ate, so that was terrible. Maybe I didn't eat enough, but my camera's a little crooked, like it's cutting my head off. Might be too low. I didn't take this camera with me for my gig. I didn't bring it, but I did bring the base that it's mounted to, so I had to remount it. And apparently I've need to tweak it just a teensy bit. If you guys will bear with me, we'll do this live because, you know, why not? Let's see. Let's get just a bit more black in there. And that's too much. There we go. That'll work. All right. How was your lunch, everybody? Do you want to know the dream that I had with you yesterday, Aurora? This sounds terrible. Yes, of course, I do. I'd love to know. Do tell. And while you're getting ready to type that, let me just have I been here long enough to quit yet? Greeners, you can't quit. Only Funsies gifting memberships.
Hello?
Only Funsies, thank you. You have gifted a. I'm not going to say a boatload of memberships today. Thank you so much for your generosity. It means a ton to me and to my family, and obviously to the wonderful people that you hit with all these gifted memberships. Thank you so much for your generosity. While you're doing that, there's a case we followed, and this goes way back. This goes back to the reason why I won't go to Georgia. Right? The Hannah Payne trial. Do you guys remember Hannah Payne? She was the driver, road rage, pulled over, might have been having a medical incident, ended up shooting the guy and went to prison. She is appealing.
You are banished from the state of Georgia.
Yeah. She's appealing her sentence. And the state, in their argument, their motion to oppose her appeal, listed 5 cases that do not exist and 3 quotations that do not exist. And the judge called him out on it and said, hey, you've got citations in here for cases that never happened. They're literally fictitious cases. AI. And the lady's like, Your Honor, I'm sorry. I wrote that and then it got edited. I don't know what happened to that. And he's like, it was in your original brief before it was edited. And she's like, I don't know. I'll look at it and then I'll provide a supplement. He's like, okay. And I'm like, okay? You're just okay with that?
Your Honor, good afternoon. We're back on the record with case on trial.
Anyway,
we have all our jurors here. Shall the
good.
witness resume the scene?
I'm sorry?
Witness?
Yes, please.
Witness may resume the stand.
Wow, the clerk just runs the show here. That's awesome. Oh, good. Nice. Get 2 good coughs in. Just kick things off. We're off of the 420 now. On to 422. Oops. So the Hannah Payne situation. Watch that Supreme Court. Yeah. Fake case. Fake case. It was nuts.
Remember in the beginning when we started 110 years ago?
There's our defendant. There's Judy Church.
Yes. Yeah, they covered it.
Accused of killing her longtime boyfriend, who was also someone else's longtime boyfriend. There's another cough. Using basically antifreeze, or windshield wiper fluid with antifreeze, mixed in or in place of his Powerade beverage. He died an excruciating, painful death as his insides shut down and crystallized him to death. It's not pretty. It is not pretty. All right, we've already had the other significant other of the victim has already been up on the stand today and testified. The witness that was up this morning referred to the defendant as Grandma. The defendant referred to the victim as, I'm not going to say it. It's a C word and it's very bad. It's naughty. But it's been spicy, and it's going to get spicier because we know there are some messages that are going to be coming in between the victim and the defendant. And C is for chat. All right, yes. It's not candy. It's not cute. Chat on screen would be nice. What are you saying? What are you saying, Josh? You take Chuck Norris's name now that he's not here to defend himself, and I think you can push me around a little. You can. So, all right, we're waiting for the jury to come back. Maybe somebody was tied up, not literally. Hopefully, I missed the gifted. Oh no, I missed the gifted. Well, they just happened again. Only funsies. Thank you very much for another 5. We are running out of people in gray, so I don't know what. Here's what you can do. Go get your friends. Go get your friends. Say, we're running out of people to gift to. Come on in real quick. We need somebody to take to come get a gift. Only funsies. Thank you. Thank you. Thank you. Let's see. Lisa's like, I'm here, right here. Make sure your settings turned right. Make sure it's you're allowing YouTube to gift to you in case it becomes available. Gray is the new green. Love it, Tisha. Good to see you here as well. Welcome. It's been a bit since you've chatted, so good to have you back. Here.
All right, for the jurors.
I think he's saying all rise for the jurors, not the judge. My toggle has been toggled, says Squinty Bubbles. You toggled the toggle. I haven't won the lottery. I worked.
Be seated.
Now you have to finish this. You have to finish this statement.
Quiet, Mr. Scully.
Thank you, Your Honor. I just have a few more questions about the pictures from Exhibit 33 that we left off on. I'm going to scroll through a few to get to the end, so if we could get
Thank you
help
so
with that,
much.
Ms. Moore.
Only funsies, thank you. Thank you. Your generosity is amazing. All right, here we go. I'll be quiet now. Let's listen to the witnesses. They're scrolling through images.
Okay, if we could back it up one. All right, so this image on Exhibit 33 appears to be the top of a can of soda or something with orange underneath it. Is that fair to say?
Yes.
And if we go to the next image, you see the Fanta soda can, right?
Yes.
And so that means that that's the Fanta soda can that would have been delivered from the collection of evidence to the Massachusetts State Police Crime Lab in this case, right?
Again, I didn't see this item, so I really can't speak to where it came from.
You did testify on direct examination, I think, though, to some of your actions with the contents that were believed to be from that can. Is that right?
Yes.
And the contents were assigned 2-4 as a number. Is that right?
Yes.
Okay. And so that can there, do you happen to know whether that can still has liquid in it?
Again, I did not see this item, so I really can't speak to the nature of it.
Okay. And we may have covered this earlier, I just forget. So was a portion of the item 2-4 saved at the Massachusetts Crime Lab, or was it all sent, the whole portion sent to NMS for testing?
So for item 2-4, which was the liquid in the specimen container, a portion of that was sampled out and sent to NMS. The remainder would have been retained in that specimen container and sealed.
Okay, and sealed. All right. All right, thank you. No further questions.
Mr. Camellia.
Just a couple. You said on direct examination that you wore protective clothing or gear when you sampled the Powerade bottle so as not to compromise fingerprints or DNA. Is that correct?
Yes, it's referred to as personal protective equipment.
All right, PPE. What sort of PPE were you wearing when you did the Powerade sample?
So I had a clean laboratory coat on, as well as safety goggles, a mask, and gloves that were changed out frequently.
Okay. And with regard to the other two items, item 2-1, which was the de-icer, and 2-4, which was the liquid in the specimen, did you note any odors or smells associated with those two items? We'll start with 2-1, the de-icer. Did you notice any odors associated with that?
So I did not note any characteristic odors for 2-1.
How about 2-4, the specimen, the liquid in the specimen container?
So for item 2-4, that orange liquid had a very subtle fruity odor, not as strong as the fruity odor in 2-2.
Great. Thank you. Nothing further, Judge.
Mr. Scully.
Just a quick follow-up on the fruity odor. So are you aware that denatonium benzoate is an odorless substance?
I don't know any specifics about that chemical.
Okay. And are you aware that that's a bittering agent?
Again, I don't know anything about that chemical.
Thank you. Fair enough. No further questions.
Thank you, Ms. Brown. You may step down.
He insists on asking the question,
I'll return Exhibit 33.
even though she's not the right witness. The fruity odor follow-up.
Dr. Naomi Shin.
Let us know.
Dr. Naomi Shin next. I'm going to count that as a cough. It was a long clearing the throat. Do they even listen? No, they don't.
Right this way. Can I ask you to stand behind this blue line?
You'd raise your right hand for me, please. Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth so help you God? Yes. Thank you. You may be seated.
Good afternoon, ma'am. In a nice loud voice, could you introduce yourself to the jury and spell your last name?
Hi, I'm Naomi Shin, last name S-H-I-N.
And ma'am, what do you do for work?
I'm a nephrologist, a kidney doctor at Mount Auburn Hospital and actually Cambridge Health Alliance Hospital too.
All right.
Wow.
And Could you tell the jury a little bit about your educational training and background, please?
Oh, certainly. So after finishing medical school at UMass, I went to residency at Mount Auburn Hospital and then further trained in nephrology specifically for about 5 years at Yale University in Connecticut. And then I came back to be an attending physician in nephrology at both, like I said, Mount Auburn and Cambridge Health Alliance hospitals.
Okay. And so obviously a nephrologist is what sort of doctor?
A kidney doctor.
Okay.
They don't listen. They don't listen.
What is it? Well, let me start over again. What is it that nephrologists, kidney doctors do, sort of aside from the obvious, which is, treat kidneys, but what is it that you all do as a specialty?
Sure. When patients come into the hospital, we treat acute injuries to the kidney from whatever etiology or cause. So whether it's from low blood pressure, which is a very common cause of kidney injury, to hereditary causes, to patients who need dialysis, which is a machine that does the job of the kidneys. It takes your blood, it cleans it up, and then it gives it back to you. So the kidneys do a lot. They clear your blood of toxins. They make sure that you're not volume overloaded. In other words, what you put into your body needs to come out. Otherwise, we'd all balloon up. The kidneys help with that. Blood pressure. Electrolytes management. So any of those arenas that patients have trouble with in the hospital, I help take care of if requested as a consultant.
Okay. So you kind of anticipated my next question about what is it that the kidney does for the body, and it sort of functions to process a lot of the waste in the body. Is that one thing?
Definitely. So the kidneys do a lot. They take your blood, they filter it, they get rid of all the waste products that we generate normally ourselves, right? Just by living, we generate waste products, and it gets rid of that through the urine. We eat and drink what we drink. We don't want to balloon up. We need to get rid of that fluid if we're not using it for whatever reason, right? Exercising, we need a little bit of extra hydration, etc. The kidneys know and figure out how much fluid you need to keep or lose. Blood pressure management is really important. The kidneys have sensors, and they can figure out if your blood pressure is low or high and respond accordingly. Electrolytes is a big thing, sodium, potassium. Again, things that you generally consume. The kidneys will be able to figure out and get rid of anything that you don't need. And then extraneous waste, so things that normally aren't in the body, medications, breakdown products. The kidneys know to kind of get rid of that in the urine.
All right. And so you were saying essentially that the kidney can be injured in lots of different ways. Is that right?
Exactly. Anything from straightforward trauma, right? Blood loss is but the most common, though. So the kidneys are very sensitive to blood flow. They demand a certain amount of it. So if you have low blood pressure, the kidneys don't like that, and they will be injured. And the cells within the kidney will start to die. Sorry, what was the original question?
No, that was the question.
Okay.
Now, ma'am, I want to ask you some specific questions about a specific patient that you assisted with by the name of Leroy Fowler back on November 12th of 2022. Do you remember that particular case?
I do.
Okay. And in preparation for your testimony today, have you had the opportunity to look over the medical records from Mount Auburn associated with Mr. Fowler's care at Mount Auburn Hospital?
Yes, I did.
Did you also have the opportunity to look at the medical records from Anna Jake's hospital where he was before he came to Mount Auburn for that particular illness?
Yes.
Had you, the Anna Jake's hospital records, had you seen or were you familiar with the information contained in those at the time you were actually treating Mr. Fowler on November 12, 2022?
I did have most of the critical pieces of information from Anna Jake's because we have access to some of the notes that the physicians write, and that's in our system. So I read all of those notes.
Okay. So when was it that you first became involved in the treatment of Mr. Fowler?
So on the morning of November 12th, which was a Saturday, I was paged pretty early from our intensive care unit at Mount Auburn Hospital. And they were concerned about, his kidney injury. He clearly had it per his blood tests. But then a slew of other findings made them very concerned that the kidney injury was preventing him from getting better. So when I was paged and I spoke to the the ICU resident, I believe it was a he, but he was concerned that there might have been some sort of ingestion involved because of the abnormal lab results, the metabolic acidosis, the osmolar gap, which I could talk more about in a second. But when that kind of information comes to me, they're red flags, because the combination of kidney injury with severe acidosis with an osmolar gap makes me think of very few things. Each individually could be any number of things, can cause any of those individual pieces, but together, that heightened my sense of urgency. And so then I went to see the patient. He was already intubated, sedated, so, I couldn't really examine him. He wasn't able to talk to me, but I collected a urine sample and I brought that back to my office and I spun it in my lab. Spinning is a very common technique that we are supposed to do to look at the urine to see if there are any diagnostic clues about what's going on in the kidney, right? So the kidneys filter blood, they make urine. So that urine is kind of like liquid gold. It can give us a lot of important information about what's going on in the kidney level.
So when you spun the kidney, is that kind of separating out various parts of the urine so you can look at them? Or
The lawyer's away from a microphone.
So when we spin urine, it's actually just because the urine sample is so diverse between lots of people, right? We want to make sure that we just look at the cells and the crystals and any other components in the urine that's important. So when you spin something, the cells and everything get pushed to the end and kind of clumped together and concentrated. And that's what we want to look at. And that's standardized. That's how we're trained, so that this person's urine is, we're comparing apples to apples. This person's urine is now comparable to that person's urine and compared to somebody else's urine, right? So, because we're concentrating the findings instead of, if you look at something that's very dilute, then you might just miss it, right? Because there's only like one or two little particles that you're interested in this big sample, and we don't want to miss something. So that's why we have to spin it down into a little pellet and then look at that under the microscope.
So what did you see when you spun the urine and you looked at this kind of critical part of the urine that you're looking at for diagnostic purposes?
So I've seen thousands of urine samples, and what just stood out immediately were the number of crystals in the urine. Again, certain crystals by themselves are nonspecific, but the backstory plus the fact that there were so many of these calcium oxalate crystals, they were mostly fan shaped, some of them were needle shaped, is just classic poisoning by ethylene glycol was the top of my mind as soon as I saw that, because now the four pieces together just really hones the diagnosis.
All right, so the first thing that you see is these calcium oxalate crystals. And you said that they're in multiple different kinds of shapes?
Correct.
All right, and so you mentioned one as a fan shape. Is that like a hand fan, kind of like if you're...
Exactly. It's a little fan. Sometimes there's two of them, so that we call them dumbbells because they kind of look like the dumbbells that you work out with. A lot of calcium oxalate crystals are actually kind of needle shaped. And there's also the envelope, which is a dihydrate calcium oxalate crystal. The dumbbells or the fans are monohydrate calcium oxalate crystals.
All right. And we're starting to get into it, but why are these particular crystals so concerning for you when you look at a urine sample, and in particular when you looked at Mr. Fowler's urine sample?
Because, again, it's the combination of the sick patient who's altered, the acidosis, the osmolar gap, plus the urine crystals in the setting of kidney injury that really, I mean, honestly, in my years of training and experience as a attending nephrologist, it's a must not miss diagnosis. It's ethylene glycol poisoning. Those are the top three things that you're thinking about. And then maybe there's something else that the person ingested, which is kind of secondary because the treatment often overlaps, like the treatment for any of those other ingestions. The treatment of urgent hemodialysis can often be life-saving.
So you've mentioned a couple of times a couple of other things that were very concerning to you. One of them was metabolic acidosis. What is that?
So our body is exposed to acid, right? In the form of diet, in the form of our cells when they break down certain compounds, they release acid. It's a waste product. We're only supposed to have a very small amount of acid in our body, and our kidneys are very smart, and they will balance that so that you're not constantly in an acidic state. If you have acid, then the kidneys will generate more bicarb, which is an alkaline compound, and then together it's neutral. You get neutral pH in your blood. That's supposed to be normal. When somebody has acidosis, what that means is that that acid level is just rising. And especially with kidney injury, the kidney's not able to work normally. So the amount of bicarb and alkaline material it's trying to generate is low. It's not normal. So now you do have an acidic state in your blood instead of a neutral pH. And so that's why I was concerned. Something was generating all these extra acid molecules. And ethylene glycol breakdown, it's one of the first breakdown products in our body is glycolic acid, and that's the driver of this anion gap metabolic acidosis. It's a term for a specific type of acid buildup in the blood.
All right. So you just mentioned the next term I was going to ask you about, an anion gap. What is that, and why is that something that you look at when you have a concern about someone's kidney?
It's a way for physicians to be able to figure out where this acid is coming from. Is it because they're having massive diarrhea and they're losing a lot of alkaline material, and so the amount of acid to alkaline material in your body is off because of that? Or is it because of you ingested something, or because you're very sick and your blood pressure's super low and then there's acid being built up in your body and created by your cells? The anion gap is an old tool that looks at the electrolytes that are measured, because we cannot, even in our modern state, measure every single thing in our body. We can't. So we take what we measure and then we calculate what should be there, and we look at that difference and we say, well, that's not normal. Normally, there's only supposed to be a small difference between what we measure and what we calculate as what should be the right answer. Because when you measure the anion gap, the computer does it, and then when we calculate the anion gap, we do it. But basically, it's what we measure versus what's actually present in the body. And if that gap is not normal, then there's something that's driving that difference.
Was Mr. Fowler's gap normal?
No.
So it was concerning to you for kidney injury?
In the setting of kidney injury and as the cause of kidney injury, yes, it was concerning.
Now, what about an osmolar gap? You mentioned that earlier. What is that?
Exactly. So that's also something the computer can measure as osmolar is a fancy way of saying what will water do in this situation. If you've got a high osmolar situation, then the water will be dragged into a very concentrated situation, and that water movement is important for us because our cells live in a water aqueous solution. So it affects our cells. So bottom line is we measure the concentration of our blood, and one way to measure that is called osmolality, and the machine does that. And then with our tools, we can actually calculate what we think the concentration should be, depending on the labs that we have available to us. And so after, years and years of data, we know what a normal difference is between the measured versus our calculated osmolality. And so if there's an odd difference, right? Like, why is what I'm calculating not what's appearing in the machine? That means the machine is measuring something that's driving the concentration of blood to be very high, whereas we're saying these normal things that are supposed to be in your blood that we are measuring through the sodium, the chloride, the bicarbonate, the BUN, the glucose, it is not telling me that it should be this high. There's something else in the body that tells you that there's something that shouldn't be there that's in the body.
So when you have an anion gap, you have an osmolar gap, you have metabolic acidosis, and you have fan-shaped and crystal-shaped calcium oxalate crystals in the urine. What's at the top of your differential diagnosis for those four things?
She was making being a kidney doctor
ethylene
sound
glycol
fun.
toxicity.
Now,
Ethylene glycol toxicity.
in addition to those four things, are there any other signs that you look for once you suspect ethylene glycol toxicity? Are there any other things that you look for either in the tests that you're running or in the physical appearance or presentation of the patient themselves that sort of can help you confirm that diagnosis? We can start with the tests. Are there any other tests that you can run to sort of confirm that diagnosis?
Sure, you can try to measure the actual ethylene glycol level in the blood, but we know that that takes a long time for most hospitals, even the larger ones. It's usually like a send-out lab. You have to send it to a specialized lab that can do it. We can also test for some of the breakdown products. Some of the hospitals may be able to do that. But more commonly, things like lactate, which is a commonly found acid in our blood, can actually be falsely high because the machine that normally measures lactate sometimes can't differentiate oxalate with lactate. And oxalate is one of the breakdown products of ethylene glycol in our body. So there are a lot of cases where lactate is very elevated in the blood, so that also can be a hint. We have some volatile alcohol screening tests that we have to see if they've ingested methanol, but ethylene glycol is often not in that panel.
Were there any other tests that you were running specifically on Mr. Fowler, either that you ran at your hospital or that were done by Anna Jakes, that gave you, that heightened any concerns about these ethylene glycol toxicity issues, or have you covered it?
I think we covered it.
Okay.
Yes.
Great. Now, one of the things that you mentioned was the metabolites of ethylene glycol. What's the difference between these metabolites for ethylene glycol and ethylene glycol itself?
So ethylene glycol is what we call a parent compound, right? This is what it originally starts off as, and then in our body through various proteins and enzymes, it gets broken down so that eventually it gets removed from our body because it's not something that's normally in our body. So ethylene glycol itself is actually not that toxic, which is surprising. But as soon as it starts breaking down by the liver, by ADH is the first enzyme, it becomes glycolic acid, which is toxic to several organs. And then that gets further broken down in our body to oxalate. And that is what binds to the calcium in the kidney and creates these calcium oxalate crystals, which is what we see in the urine often.
So for Mr. Fowler, when you run these tests and you look at the calcium oxalate crystals, the gaps that you talked about, what are you trying to do now to help him sort of survive this condition?
So get rid of the ethylene glycol. Get rid of that initial compound because then it's not going to break down into further compounds. Either that or stop the compound from breaking down. And so we have a medication called fomepizole, which blocks that first enzyme that starts breaking down ethylene glycol. So we gave that immediately. And then while that was going, I tried to get hemodialysis started. Again, that's the procedure where a machine does the job of the kidney. It takes your blood, it gets rid of any waste products that shouldn't be there, and then it gives you the cleaned blood back. Because that removes both the ethylene glycol and actually its breakdown products. So it'll be able to get rid of all those toxic metabolites as well.
And if you have a pre-existing kidney issue or kidney problem when you're exposed to ethylene glycol, what does that do to the body?
So the ethylene glycol would stay in your body. The kidneys would not be able to get rid of it effectively. So now all of that ethylene glycol is being broken down into its toxic metabolites, and that's also pretty much staying in your body longer than it normally would if the kidney function were normal.
Now,
I have to adjust the volume 10 notches.
Is hip and back pain a sign of any particular thing that would be concerning to you for somebody who's complaining of kidney issues or kidney problems?
I would definitely consider it. Obviously, there are some more common problems of hip and back pain, but combine it with any urinary symptom, and I'm heightened to think that it's the kidney. It's not your muscles. It's not your bones. It's the combination of any kind of lower flank pain with urinary symptoms, because that's what the kidneys do, would make me think of kidney injury.
So urinary issues, would that include an inability to urinate?
Definitely.
Your Honor, at this time I'd like to mark the medical records from Auburn Hospital subject to any issues as the next exhibit.
It may be marked.
Not a problem, Judge.
All right. Is defense going to try to attack this witness?
And ma'am, you had already indicated to us that you had the option to the opportunity to take a look at the medical records from Mount Auburn before you came in here today. Is that correct?
Yes.
All right. And you, in addition to numerous other treating physicians and PAs and nurses and everybody else at Mount Auburn, did a report in connection with your work on this particular case. All right.
Wanders away from his mic and then back again. Kitty Cat, welcome. Good to have you here.
And ma'am, I'm sorry? What page number and volume at? 31. I'm just going to hand you, ma'am, one page out of those medical records that we just marked as the next exhibit. Do you recognize the image at the top of that page?
Right. So this is the dumbbell shape. So you've got like the two.
Stop you for 1 second there. So you recognize that as a photograph or an image that you placed in your report in connection with this case?
This is from my note, from my initial consultant note in the morning, and I took a photograph of what I saw in the urine in the microscope.
All right. We have actually it's already in evidence. I'm just going to put it up on the screen for the jury to take a look at. All right.
We're now joining science class to look into the microscope at urine crystals. Here we go. Make sure you watch this on your big screen if you're able.
All right.
There it is.
Now, Doctor, if you could see on the screen next to you, you should be able to see that as well.
Yes.
And it's a little bit blurry, but that's because it's the way the image was created. Could you tell us what we're looking at there?
Yes. So the backdrop is urine, and it's very a tiny amount of backdrop urine because, again, we spin it down and we concentrate whatever's in the urine into a very standardized volume. So in the backdrop, there's urine, but right in the center is this, there are two fanned out shapes that are connected, and you can also see the lines of the crystalline structure, but that's what we call a dumbbell-shaped calcium oxalate crystal.
Okay. And those are particularly associated with ethylene glycol toxicity?
Only in the context of having all those other pieces together. Calcium oxalate crystals alone are actually not that specific. It's just, again, all those 5 pieces of information together now hones in the diagnosis.
Awesome. Great. Thank you. Now, you learned during the course of your treatment of Mr. Fowler that he had some cocaine in his system. Is that correct?
Mm-hmm.
Any of those, the osmolar gap, the anion gap, the crystals, are those concerned? Would those be associated with cocaine or cocaine use?
Not directly. So cocaine use can wreak havoc on the cardiovascular system. It can make your blood pressure go high. It can make your heart race, right? Your heart rate's going fast. And at that point, your body's trying to also respond and regulate. And so it can cause muscle injury, like the actual cocaine use itself, or blood pressure variations to the point where we get certain slightly abnormal lab values, but not this combination of like an anion gap, acidosis, and certainly not an osmolar gap. No, you would never get an osmolar gap with cocaine use.
And same with the defense. Mr. Fowler. He had a pacemaker. Any concern that the pacemaker would have sort of created any of these, a misfunction or a malfunction of the pacemaker would have created or caused any of these symptoms that you were seeing?
Theoretically, if, his blood pressure were low, but actually his blood pressure was pretty normal throughout our hospitalization. And if you look at the Anna Jacques records, it was actually pretty normal there too. So no, nothing directly about a pacemaker would make, these lab abnormalities.
All right. There's one other thing you can do. Where's the bell? Yeah, what are the Did Mr. Fowler's presentation at Anna Jake's and then at Mount Auburn follow a particular form of ethylene glycol toxicity that you're familiar with?
Yes. So ethylene glycol toxicity usually takes kind of 3 stages. Very early on, neurologic. So almost like somebody who's drunk, they're inebriated, their central nervous system isn't, working properly. So it's very nonspecific, right? So they just act confused and not normal. But second stage, you start seeing things with their heart and lungs. So blood pressure can be high, heart rate can be abnormal, it can be very high. And then there's actual lung injury. So then patients actually have trouble breathing. And then the third stage is kidney injury or sometimes just outright failure, where you can't even make urine anymore. So that's much later on. But like I mentioned before, there might have been other reasons why you could have kidney injury. So it can get very messy, but usually those are the 3 classic kind of stages of ethylene glycol toxicity: the brain, the heart and lungs, and then the kidneys.
All right. Now, one of the things that you did not have the advantage of when you were treating and trying to diagnose Mr. Fowler was the result of any blood test for ethylene glycol on November 11th or November 12th, 2022, correct?
Yes.
Okay. Now, in preparation for your trial testimony here today, did you learn that blood was taken from Mr. Fowler at Anna Jake's Hospital and later tested for ethylene glycol during the course of essentially his autopsy?
Yes.
Okay.
I found that in the report, yeah.
Okay. And the combination, and you learned that his ethylene glycol levels in his blood were 52 milligrams per deciliter, is that correct?
Correct.
Now, the combination of everything that you've talked about for us today, the anion gap, the osmolar gap, the metabolic acidosis, and the calcium oxalate crystals in the urine, when you combine that with ethylene glycol, a positive result for ethylene glycol in a blood test, do you have an opinion to a reasonable degree of medical certainty what the diagnosis would be under those conditions?
Certainly. It'd be ethylene glycol toxicity.
Great. Thank you. Judge, I don't have any more questions. I would like at this time to mark the Beth Israel medical records with the same.
Subject to potential redaction. Yes.
Thank you.
Mr. Narconis.
Thank you, Judge. Good afternoon, Doctor.
Afternoon.
See how they do here. Oh, this is the aggressive guy, right?
I have no medical training. Tell you that
Which is
before I
going to be
begin
very
with
apparent.
These questions. But
He also has no microphone skills.
you indicated there are 3 phases generally accepted within someone who does have ethylene glycol toxicity, right? And the first one would be a person has it, and they may appear to be what we normally associate with somebody who's drunk. They're losing muscle control, they might be falling down, they appear to be a little bit dizzy. They could even be, some people get nausea, right?
Mm-hmm.
With that and that. And in the context of, and then you had gone into 2 other phases, which I'll ask you about in a minute. But when a person ingests ethylene glycol, that's quickly absorbed by the water. Is that correct? And that within the body.
It is quickly absorbed into your blood, yes.
And would it be fair to say it has, the term I've seen used is a very short half-life, the ethylene glycol itself?
Mm.
And
so this is tough.
What that really means?
Yes. So any compound has what's called a half-life. Like how long will it last in your body? And so that's why we care about things like, is the liver working? Is the kidney working? Because all of those pieces usually are involved in what takes, X amount of hours or even minutes for a certain compound to just break down in your body. Okay. So ethylene glycol, though, is tricky. If you look at the literature, if your kidney function is stone cold normal, then fine. Few hours, usually about 4 and longer and change, is the half-life of ethylene glycol, if I recall correctly. So I'm not a toxicologist, I'm a nephrologist, but my point is, what that means is that if you have, let's say, 100 units of something, right? What is the time that it will take to get rid of half of it? That's a half-life. And so, you know, it's usually on the order of like hours for ethylene glycol, but that's if the kidney function is normal. If the kidney function is not normal, the kidneys are the ones that are getting rid of it. If they're not functioning, then your ethylene glycol level will be higher. It won't be the usual 4 to 8 hours, I think it is. It's going to be pushed further back to about 12, if not longer, in your body.
So, a person consumes ethylene glycol, and you've indicated, it's like initially ethylene glycol by itself, without any metabolism within the body, would not be destructive if it didn't go into all of those other pieces, correct?
Correct.
And at some point in time, ethylene glycol, one of the side effects, bad side effects, is the calcium oxalate crystals in a person's kidney, right? I hope I'm pointing to the right spot of the kidney.
Yeah.
Myself, I don't even know where they are. But it's the ethylene glycol, and that is part of the metabolism process, creating the calcium oxalate crystals.
Right. So the ethylene glycol is broken down. And the first step is mostly in the liver, actually. So the enzyme that we care about, ADH, alcohol dehydrogenase, is in the liver. And so the ethylene glycol gets broken down into glycolic acid, and then ultimately broken down further into oxalate.
Now, it's a timeline type issue. You've told what happens in stage 1 before we get to stage 2. So some of that ethylene glycol now has disappeared from your system and become oxalate crystals, right? Calcium oxalate crystals?
Mm-hmm.
Would there still be...
Is that a yes?
The process then is the crystals themselves don't go over into those other 2 acids you mentioned. They don't become part of that, they don't further metabolize into the acids, right? So it's almost like there's a divide someplace in my body. Some crystals, some of the ethylene glycol is going to create crystals, and some other aspects, as it metabolizes, is going to become the acids. How does the ethylene glycol that's changing not all become crystals in my kidney?
Let her answer.
Because the body's not perfect. So this is why we talk about half-lives, right? We have a certain amount, and then in a certain amount of time, we have half that disappears, right? So, and then we have that same amount of time, and another half disappears. It's first-order kinetics. So, it's not like this beautiful, straight line. Some of it's going to be broken down into, glycolic acid. Some of the ethylene glycol is still in our body, later to be broken down into glycolic acid. And then some of that glycolic acid is broken down into oxalate and deposited potentially in the kidney. But it's just not a beautiful, clear-cut breakdown. The body's kind of messy. So we have these things where we say the half-life is a huge range of hours. It's not just a specific number. And then you add on kidney injury, and the range becomes even wider. So it's just hard to predict exactly how it's going to be broken down. It's a little messy.
Okay. And in the context of so there's 3 things going on at one time. There's ethylene glycol still floating through the bloodstream.
Mm-hmm.
There's some crystals being created.
Mm-hmm.
And then there's some metabolism taking place in terms of the acids. And that's all simultaneous.
Yep.
And so, and at some point in time, though, all of the ethylene, if you were doing a blood test, when you get to stage 2 or 3, you've talked about, you wouldn't find any actual ethylene glycol anymore in the system, correct? It would now have either metabolized or gone to crystals? Time goes on, there's a timeline, right?
Yes.
And at some point in the timeline, the person could still have the crystals and still have the acids, which are causing all the further damage, but no longer would the blood test show ethylene glycol itself.
It's possible, yes.
But do you think it could also be the other way? You could always test for it some period of time.
Yes.
At some point in time, did Anna Jakes, did Mount Auburn, though, send out any blood to be tested? Let me strike that question. Do you use Quest in the hospital for your blood tests?
Not always.
Quest Diagnostics. It's a big testing company.
Let me show you one page of the records. Page
They've tested a few of my
25.
samples.
I may approach Judge.
Yes, you may.
I think they've only taken blood from me.
Oh, okay. Yeah. 1113. Okay. Right. Okay.
Doctor, I'd ask you to look at that page. Does that indicate that that's a record from the Quest lab at Mount Auburn, blood lab?
Yes, so it's dated, the collection is actually 11/12/22, 13/42, so he is
Does it say
physically
that
still at
ethylene
Mount Auburn.
glycol
Yeah.
none detected?
Yes,
And that was on 11/11, correct?
11/12.
11/12. Right.
So he's at Mount Auburn. This is a Mount Auburn sample.
So that was after he was transferred to your hospital.
Mm-hmm.
And the first, would that have been the initial test itself, or that would have been a subsequent test?
Subsequent, because he arrived, I might have to go through my notes, but he arrived somewhere late 11/11 to early 11/12, after midnight on 11/12 is I think when he actually arrived to Mount Auburn, and then we started collecting our own labs. So this being collected at 1:42 in the afternoon means he's been at Mount Auburn for a little bit on this day.
So that would have been 1:22. That would have been 12 o'clock, 1 o'clock on the 12th.
Correct.
If I can reclaim that.
Yeah.
Man, this guy's so far from a microphone, I have to crank the volume all the way up and then turn it down before she starts talking, because she is right on top of the mic, and he is far from it. It's a pain in the butt. But I like this testimony. She's doing a great job.
The stages, then, I think you've talked about that. In stage 2, you could have rapid breathing. You could have a very fast heart rate, correct? And if a person had a pacemaker, the pacemaker would be trying to deal with the fast heart rate.
Mm-hmm. Although normally it prevents low heart rates. Like if your heart rate's really low, the pacemaker will make your heart pump at a certain rate.
Now, and then in this particular case, then usually stage 3 with that type of ingestion is renal failure, which causes your death, right?
It's usually cardiovascular collapse, actually.
He died of a stroke, right?
It'd be part of cardiovascular system, yes. But it's really interesting because he came into Anajax with a kidney injury. So this makes everything very murky, right? So if you already have your kidneys injured, again, it could have been from something else, and then ethylene glycol is introduced. Now things get really messy because like that half-life of ethylene glycol is now just expanded. And those clean, stages don't really exist, and the timeline for those stages are much less clear.
So the aspect of this, though, where normally, or not normally, but in many cases, the person who has ingested the ethylene glycol, the cause of the death is the renal failure, right? If that is from your experience as a doctor. My kidneys don't work. What happens to me?
So actually, people who have kidney disease, they generally die from their heart. The heart cannot tolerate the environment that has been created because the kidneys are failing. Acid levels rising, blood pressure is abnormal, electrolytes are so abnormal, the heart is no longer able to pump normally because we use the calcium, we use potassium to be able to regulate our heart signaling and pumping. And so when the calcium and the potassium are not normal because the kidneys have failed, that's when people get into big trouble and they have cardiac events. So I can speak to end-stage kidney disease, but, ethylene glycol toxicity, usually kidney failure is blamed as a big part of why the patient died. But again, in the setting of kidney failure, it's usually the final thing that does it is usually the heart gives out, right? Because it's almost like semantics, right? Like if the kidneys have created an environment that is so bad, your heart will stop because of that. So are you going to blame the heart? Are you going to blame the kidneys? I would say both.
At some point in time, though, on the 12th of November, your hospital, it might have been under your direction, you gave him dialysis and cured him of any ethylene glycol anymore, correct?
Yes, exactly. We removed ethylene glycol and its metabolites. However, many studies have shown that you can't predict with 100% certainty how much you're going to remove. So after the dialysis is done, then we continue to do testing like the osmolar gap, like the anion gap, to see if there's indication for further dialysis. Because like at most places, the ethylene glycol results just don't come back fast enough for us to be able to say, hey, we cleared the ethylene glycol, let's stop the dialysis. We have to, again, go by those very, very suggestive blood tests that we had at the very beginning of his presentation as well, the osmolar gap, the anion gap acidosis.
After the dialysis was done and that process indicated that the ethanol glycol was on, did you do those other 3 tests again? And did that show you that those were back to normal for Mr. Fowler?
So they were back to normal, but he was transferred to BI at that point. He became so unstable, he had a seizure, that the Beth Israel Hospital is a larger tertiary hospital. They have a neuro ICU. They've got they've got ECMO. They've got more things that could have been done. And so we had transferred him. And I know, because I reviewed the chart, that at that point it had resolved. The anion gap had resolved. The osmolar gap had resolved. And actually, I think you're right. Right before we transferred him, I think we also did measure at Mount Auburn as well, but BI confirmed it, like they're both resolved, and he didn't need any more dialysis immediately when he was transferred.
Mr. Camilio had asked you, you had looked at the results that came back from the lab that tested the Anna Jake's blood, and they came back, I think it's 52, is it milligrams
per deciliter.
Per deciliter.
Mm-hmm.
And that, would you be able to transform that into grams? Is that equal to approximately 26 grams, the equivalent of it, the 52 per deciliter?
Oh, I didn't do the math. You just would need the molecular weight, though. Yeah, so you would divide that by the molecular weight of ethylene glycol.
I'm not being good at math. I can't make that. You can make the equation from that system to the dry system. That's a liquid system, and then you're going into a dry system of grams. Is it approximately somewhere around 26 grams might be a good estimate?
Yes.
Okay. If I can have a moment, doctor, and judge, I have a moment.
Yes, you may.
All right. I either need the witness to be quieter or the attorneys to be a little louder, because my fingers are getting tired of clicking the volume up and down. There's a cough.
Within the context of treating ethylene glycol ingestion on individuals, is there a timeline within the hospitals that you can get to a person within so many hours? You can rectify the damage that the ethylene glycol may be doing? You were talking about the 3 stages. So if you get in stage 1 in 3 or 4 or 5 hours, might I be saved?
So there isn't very good data on this, because we don't randomize people to be exposed to something that toxic. So we have a lot of observations. What that means is, somebody comes into the hospital, they report that they took X, Y, and Z a certain amount of hours ago, so we have to take their word for it. We can't even necessarily be sure that that's true. So we've got all these reports, but I can't say with any certainty that, he would definitely have been saved if he were treated, within an X amount of hours. What we do know from all of these reports is that generally the people who are treated earlier tend to do better. People who have delayed treatment tend to do a lot worse and not be able to survive. But what that exact hour cutoff is, nobody could tell you that.
There had been an old, fisherman's type tale. If you knew someone had that, you give him a fifth of Johnny Walker Red right away, and that may save them.
I smile, but that's actually true. So remember, the breakdown of ethylene glycol in the liver to glycolic acid is done by ADH. It's an enzyme. We only have a certain amount of it at a given time.
Johnny Walker, Grandpa's
ADH
medicine.
also breaks down ethanol, which is alcohol, the alcohol that we're talking about when we talk about drinking alcohol. So if you give ethanol, then it will actually trick the enzyme into working and breaking that down, and it won't break down the ethylene glycol as effectively. So yes, that was an old treatment that we had for ethylene glycol and even like methanol toxicity, because you would divert and you would prevent the breakdown of ethylene glycol.
Thank you.
Get them drunk. Get them drunk. It might save their life.
Just one thing I wanted to clear up, Doctor. You said that a lot of the numbers, the osmolar gap, the anion gap, they went back to normal after dialysis.
Mm-hmm.
Now, dialysis can help to clear the ethylene glycol and the metabolites from the system, but the dialysis does not repair the damage that they have already done to the liver, to the heart, to the brain, to anything else.
No. Nope, not even the kidney. They do not actually help repair the kidney. They just literally are doing what the kidney should or would do if it weren't severely injured.
So if the injuries to the heart, the brain, the kidney, the liver are already too great, then it doesn't matter that you've already gotten the ethylene glycol out of the body.
Yeah.
Thank you. Nothing further.
Any follow-up on that, Mr. Narkunis?
No further questions, Judge.
Thank you very much, Doctor. You may step down.
Thank you.
All right. Great witness. Makes all of us want to be kidney doctors.
Thank you. William Eaton.
So if you do decide to become a kidney doctor, you're in for a surprise. Sorry. It's cheaper just to have a bottle of Johnny Walker on hand.
Judge, could I have a moment with the prosecutor?
Yes.
Away from the microphone, please.
You can still come forward. Come forward.
Just gonna ask you to stand behind this blue line. I'm Faze the clerk.
Sir, would you raise your right hand for me, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right. Already missing the flannel, so that's down 1 point. But
Make yourself comfortable in that chair.
Good afternoon. Good afternoon.
Push your chair toward the microphone.
point your
Good
chair
afternoon,
towards the
sir. In a nice loud voice. Could you introduce yourself to the jury and spell
Introduce
your last
yourself.
name?
I think
My name is William Eaton. My last name is spelled E-A-T-O-N.
And sir, where do you live?
40 Woodley Ave, Seabrook, New Hampshire.
And how long you been living in Seabrook, sir?
Since I'd say 2000.
All right. So a long time. What do you do for work, sir?
I'm a general contractor.
Okay. Any sort of specialties that you have as a GC?
I ran a roofing company, Tri-State Roofing, for 35 years.
Okay. And still involved in that business?
No.
No. New business now?
Excuse me?
New business now?
No, kind of retired.
Okay. Kind of retired now. All right. And how long you been retired, sir?
I got COVID in mid-2020, probably 21, so probably since 23.
Okay. Now, did you know an individual named Leroy Fowler, who I'm going to refer to during the testimony today as Big Leroy?
Sure.
All right. How long did you know Big Leroy?
I knew Leroy since 1978.
Okay, so your whole life, basically.
Well, his whole life.
Oh, his
but,
whole life. All right, fair. Did you guys grow up together?
No, I dated his sister and had a child with his sister, and he also had a child with my sister, so we were kind of brother-in-laws both ways.
Okay. And did he ever work for you? Were you on that roofing company?
Yes, hundreds of times.
So did you hire him as a sort of like a contractor, or
Leroy was an actual employee for me for a long time, and then he went on to do his thing, and I hired him whenever I needed him.
Okay. And when he was an employee of your company, what sort of work did he do?
Roofing, siding, framing, whatever we were into that day.
Okay.
Roofing, siding, and framing.
And did he help you with any other aspects of the business, maintaining vehicles or doing any of the other things that your
Yeah,
business was involved in?
I had a garage in my yard, and we had broke down vehicles at time, and Leroy was pretty mechanically inclined, so
Okay.
he helped out doing that stuff.
All right, and as he got a little bit older, did he stop doing quite as much work with you at the company?
Yes.
Now, I want to draw your attention, sir, to the week of November 5th into November 11th and 12th. Okay, did you were you seeing Leroy during that time period?
Yes.
Do you remember the last time that you saw Leroy?
The last time I seen Leroy was Thursday, the day before.
The day before he went to the hospital?
The day before he was admitted to the hospital, yes.
Okay. And where did you see Leroy?
In my yard.
Okay. And so Leroy had come over to your house?
Yes.
Was he by himself?
He was with Judy, but she stayed in the car that day.
Okay. So you knew Judy from Leroy's relationship with her?
Yes, we had rode motorcycles together. We had gone to like a bike week event, a couple of those, and we had hung out a couple of times.
Did he ride on the back of the black one?
Okay. The day in question, why did Mr. Fowler come over to your house?
I had an enclosed trailer, like a little box trailer, like 12 feet long, and he was planning on filling it with some belongings and going to Florida with it.
Were you going to sell it to him?
Yes, I was going to sell it to him.
How long had you been talking to him about him actually buying the trailer?
It started in like late October. He had asked me if I was interested in selling the trailer, and then it kind of went away. And then that week he had reapproached me probably on Monday about buying the trailer. So he came with Judy that day, and then me and him had talked about it for the next 2 days, and he was supposed to come on Friday morning to pay me and pick up the trailer. So he didn't show up. So I texted him Friday morning, hey, what's up? And he never responded.
Okay. So the time earlier in the week when he came, that was both him and Judy who came again that day?
The first time they did. I don't know if she was there the second time, but.
Okay. Was the first time the one when she waited in the car?
No.
No, first time she came out?
Yeah.
Okay. And so they looked at the trailer together?
Yes.
Okay. How, on Thursday when you saw him, do you remember about what time it was?
It was in the morning.
Okay. How was Leroy looking at that point in time? When you saw him?
Leroy was fine.
Okay. No issues with stumbling around or dizziness or anything like that?
Nothing. Like I said, I've known Leroy since 1978, worked with him on a daily basis. He was fine. Okay.
Did you speak to him at all, either on the phone or via text at all later in the day?
I had spoke to him. I think he called me and said that he was going to be late because we had talked Thursday about him coming, first thing in the morning, and I was going to wait around for him. But he called me and told me, look, I got to do some banking and figure the rest of this out. And I'm going to be a little late. So that's why noontime I texted him and said, hey, I want to get going with my day.
Okay. And so after the last time you saw him at your house, did you ever speak to him again?
Yes, I spoke to him on the phone that evening, at some point. Evening, yes.
Okay. And when you spoke to him on the phone Thursday evening, how did he sound?
He was totally fine.
No issues understanding him. No.
Clear as a bell.
All right. Thank you. Nothing further, Your Honor.
Got this witness, Mr. Scully?
I have no questions for this witness, Judge.
Thank you very much, Mr. Eaton. You may step down.
No questions. Take the rare pass by the defense. Move right
Richard
along.
Delaria.
Richard Delaria.
Judge, can we go to sidebar briefly?
Yes.
Off to sidebar we go. As a new witness comes in, no coughing shall happen during the sidebar by order of the judge. What was that whisper from? I had everything muted on my entire system when that whisper came through. Did you hear that whisper? The jurors have just been excused. Doesn't make sense. Did somebody do a command? Must have been a command somewhere. And now we get a break. As to why is unclear.
It's not your turn to talk.
It's not our turn to talk. Make it make sense. Somebody, I think I know what happened. We listened to the kidney doctor, and she talked all about pee right after lunch. And then we had this other witness, and they're like, we can't hold it anymore. We cannot hold it anymore. We've been thinking about it all day long now. We need a break. We need a break. That's what it was. Okay, there you have it. Who was it that sent me the link to the printable 3D, the 3D printer link to the kidney? Who sent that to me? Greeners, was that you? I don't know. I have to look at where the message came from. Print a 3D kidney. It wasn't me, says Greeners. It wasn't. Well, who twas it? Somebody has to own up. I might just print one. It's always handy to have a spare kidney around. You know, people are like, oh, I need a kidney. Well, I could, I'm not sure how well it would work, but I can make one. It's like, what color would you like it in? Rainbow? Not it. Not it. Maybe pranky would have been a better word than gaslight. Yeah. I heard the whisper. I don't know who it was. A little recap of what we had here this afternoon. The doctor, the good doctor, who was on the stand, the kidney doctor, absolutely amazing. Last name Shin, I believe, S-H-I-N, or C-H-I-N, one of the two, but it's Chin or Shin. And she's amazing. She's a kidney doctor. That's all she does is just kidney stuff. And you think, oh, yay, fun. It was Shin, says Red Pen. She knows because she made the link, or the pin. How exciting could it be to be a kidney doctor? Well, it's actually pretty exciting. It's really cool. What the kidney does is amazing, and how it does it is incredible. And she makes it sound fun. And I'm like, oh, I should have studied that instead of communications in college, because A, she makes a boatload more money than I do, and B, it sounds like it's actually a pretty cool job. Being able to, have somebody pee in a jar and you stick it on the merry-go-round in your office, and next thing you know, you can tell them what's wrong with them. That is pretty cool. I mean, it's right up there with witchcraft. I don't know exactly how it works, but that is just really cool that that she can do that. Was able to pin down the ethyl glycol poisoning because of that. I'd rather be a nephrologist than a urologist. Okay, yeah, I guess, but the two are quite literally connected. Imagine they have some. Yeah, she did mention liquid gold, and I did not make any comments about that. She's like, urine is liquid gold. Then how come they're not paying me for my samples, huh? Where's my money? Show me the money. All right, true history fact. Sailors in the old times used to hang their backsides over the side of the ship to test water temps. Where did this come from, Anna? I'm sorry. Where was the conversation comment that led up to this one? What did I just interrupt? Anna, oh my goodness, Anna Banna. It's like cool voodoo. Oh man. It wasn't their butts either. They just take a little dip in the water, see if it's warmer. I don't know. I think the whisper asked directly about sailors. Oh, okay, that was it. Off the poop deck. Yes, the poop deck, of course. You need a pot to liquid gold in. Oh man, good times, good times. All right, we're in a holding pattern. I don't know how long they're going to be a break, or quite frankly, why we went to break. It's the defense. I believe the defense called for this. They first asked to speak with the prosecution, and second, they called for a break. I would, just to the way this trial is going, I would not be surprised right now if they came back and said, we're taking a plea. It's like this would be on my bingo card for today. I mean, like, yeah, let's probably include that because there's just a chance. This one has just been, it's just been amazing. It's just been amazing. I think that would happen here. So hold tight, hold please. Why would they do that? Yeah, I know. It seems like a big jump to go from like, hey, we're taking a bathroom break to we're taking a plea deal, but apparently they're connected, and it's all in the urine. What happened today? We have the testimony, the worst, most damning testimony that we expect in this trial, aside from the sext messages from the defendant to the victim, which might have something in there that is not good, has come in during this trial, and it's been allowed in, and even testimony that the defense thought should never come in, and even motion to strike from the record, has been allowed and explained and backed up and verified with a personal experience. They have lost key battles that they needed to win, and going forward, you're looking at it's looking bad for you, Judy. It's looking bad. We've got some strong evidence against you. Do we risk it with the jury, risk it for the biscuit, or do we say, hey, Mr. Prosecutor, is that still on the table? Can we? I don't know. That's just me. I have no inside knowledge that would be the case. I just looking at what happened today, I would not be surprised if that happened. So we'll sit back and watch. Shelly Small says, I wonder if they were selling build your own voodoo doll kits. Outside the court, some entrepreneurial kid has a card table set up with a bunch of sock puppets and needles. And he's like, make your own. Traditional Polynesian navigators suggest sailors use very sensitive body parts to test water temps and ocean currents. Like their eyeball? Like, yep, it's really salty here and a bit cold. Is that? Yeah, I'm with you, Anna. I can see a little seawater in the eye. Could definitely be a aid in the navigation, so to speak. There's no plea. I put my doctor appointment on Wednesday on it. Okay. Josh says, not going to happen. Take another step. Honestly, Josh, you're on the safer side because the number of times that people take a plea mid-trial, very, very rare. Extremely rare. Sometimes the day of trial, at the very beginning, it's a possibility. But during trial, if I called this one, I would be amazed.
I have 2 minutes just as they're coming in, just to let him know that stay away from those statements.
Okay.
Okay. I was completely wrong. Looks like the witness has been advised not to say certain things, and they took some time just to make sure that witness is not going to say those certain things. And the jury's coming in. The judge has masked up, and it's game on for round 2 today. It's a prank call. I'll answer it off the air.
Thank you, Judge.
We can have that witness approach so we can swear the witness in, please.
Please follow me, okay? Stand right on that blue line for me.
It was a new prank call, and it was a really, really smart AI who, hands in the pocket, suit coat, not a good look for a witness. Doesn't look excited to be here, swaying back and forth, a little uncomfortable in here. Francis Fitzgerald, OG, member for 21 months. Thank you, Ari, for all you do for us. Happy anniversary, 327. To my hubby, thank you for 44 years of love.
Judge, this is the last witness I have today.
Love.
That's fine.
Congratulations, Francis. 44 years. You are a patient. Just kidding. Just kidding. I'm sure you are. Patience is key. The cough counter is going higher as we sit here and wait.
Come right in. We're good to go.
Bring them in. Last witness.
All right for the judge.
All rise for the judge. Judge, which is sort of like half juror, half judge. Kitty Cat, 45 years together in September. That is awesome. That's really cool. I got married in 2000, so it's really easy to remember how long I've been married, which is it's cheating, I know, but.
Be seated.
Sir, would you raise your right hand for me, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
I wish the bailiff would just yell, "On your butts," or something like that. Something just not quite so formal as "be seated." Okay, let's check out this.
Good afternoon, sir. In a nice loud voice, could you please introduce yourself to the jury and spell your last name?
He says introduce.
Richard Dellaria, Dellaria.
And sir, where do you work?
Salisbury Police Department.
How long have you been a police officer in Salisbury, sir?
18 years.
What is your current rank, sir?
Lieutenant.
What is your current assignment?
As lieutenant, I oversee all patrol operations as well as all administrative functions of the department.
All right. As a patrol supervisor in Salisbury, as a lieutenant in charge of the patrol, do you generally wear a uniform?
Not usually.
Usually plain clothes?
Correct.
Okay. When you do you ever do shifts where you do wear a uniform?
Yes.
What are those types of shifts that you're doing?
I can take extra supplemental patrol shifts, cover on holidays, overtime shifts, regular patrol.
All right. And when you do those regular patrol shifts, are you generally wearing a body camera?
Yes, I am.
Okay. Now, last week, when a couple of other witnesses testified in this case, the jury saw what has now been marked as Exhibit 2, which was a body camera footage of a response that was made to 108 Central Ave in Salisbury on November 11, 2022. Were you wearing the body cam that filmed that particular call for service?
I was.
Okay. Were you the only person that responded that day who was wearing a body cam?
I was the only officer that entered the house that was wearing a body camera.
Okay. Now, when you entered the home, what observations were you able to make of Mr. Leroy Fowler?
Mr. Fowler was seated in the bedroom on the floor. I didn't have direct contact with him, but over the other medical personnel, I could see that he was struggling, grunting. He was in obvious distress. It appeared like he was grasping out, trying to use his hands to grab onto something to possibly pull himself up. He was struggling.
Okay. Now, the medical personnel that were in there asked Mr. Fowler a number of questions. Is that fair?
Correct.
Was he able to answer any of the questions that they asked while you were standing there watching them provide treatment to him?
Not to my knowledge, no.
Okay. Who answered the questions that were being put to him by the medical personnel?
His girlfriend.
Is that Miss Church?
Yes.
Okay. Now, while you were observing Mr. Fowler, were you able to observe the floor in the bedroom around where he was sitting?
A little bit, yes.
Did you notice any signs of drug use there? Any pills, any cocaine, any paraphernalia of any sort?
Nothing.
Okay. Now, when Mr. Fowler was carried out from the apartment, or the unit, whatever you want to call it, was he able to start talking at that point?
No.
No. At any time that you were present with Mr. Fowler, from when you entered the apartment until they put him into the ambulance, was he able to say anything?
From the time he was picked up off the stretcher and put in the ambulance, I was able to make out something about a dog or his dog.
Okay. And that was it?
That was it.
All right. Thank you. I don't have anything further, Judge.
Last witness for the day.
Just a few questions, I think.
Not the last cough.
Good afternoon, sir.
Good afternoon.
So when you responded to this scene, you had body-worn camera on, right?
Correct.
And people were moving through the house and dealing with Mr. Fowler, right?
Correct.
And EMTs and fire were arriving, right?
Correct.
He was being taken out, right?
Correct.
Judy Church, who's seated over here, was present and providing some information, right?
Correct.
Okay. Now, one thing that you did is you deactivated your body-worn camera at 16:15.
Correct.
Is that right?
Yes.
And that was before Mr. Fowler was loaded into the ambulance, right?
Yes, it was just after he was walked out past me down the ramp.
Right. And he's with Jonathan Lemke at that point, right? Do you know who that is?
I don't.
And are you aware that Jonathan Lemke participated in a recorded interview with Trooper Williams about his interactions with Leroy Fowler?
I was not aware of that.
Okay, and are you aware that Lemke had, in fact, conversations that you weren't
Objection,
present?
Judge.
Sustained. He sustained.
Right.
He doesn't know Lemke. He's not going to be questioned about what Lemke might have said.
All right, well, you weren't recording, because you shut your recorder off, the conversations, if they were taking place, between Lemke and Fowler, right?
Correct.
All right, no further questions.
He
Mr.
still wants to ask
Mayor?
questions about it.
Thank you very much, Lieutenant. You may step down.
And we're done for the day.
I'll see counsel at sidebar. Go ahead. Play on through. That was the last witness for today, so I'm about to let you go, but I just want to get a sense of scheduling before I let you go.
All right, mask up, Judge. Don't want to cough on anybody. Short and sweet. What was the point of that? I don't know what they got out of him other than I walked in. I wore the body cam that you've already seen. I saw the victim struggling a little bit about his behavior. That the medics were asking for information about the patient, the victim, and the person answering questions was Judy. Other than that, turning off the body cam and not hearing a conversation which may or may not have taken place. That's all we have from this witness. And basically, he must have been picking up an extra shift because he's a plainclothes dude normally, and he must have been working an extra day. Overtime after this, I promise the order is also short and sweet. Mathis, it's 33 pages. Yeah, we could do it. We can do that. We can do a little reading, light reading. Need him to verify the body cam, but it's already in. It's already in as evidence. The jury's already seen it. So if it was foundation, that's just... It's weird. It's weird. It was Veterans Day. Oh, Mathis says, no, I accidentally pointed to the wrong order. The relevant one is like 2 to 3 pages. Okay, that's better. Have you sent it to Josh? Or any of our mods? I should say Josh because I think Josh found it. Let's see. Ooh. Greeners just sends me a new link to a new 3D printer that's coming out. 500% faster, near zero waste. Oh, it's a true 4-color. Okay, now I need that. Oof. Never mind, I don't need it anymore. It's way too expensive. Don't need that one. Revised order Josh, is it first or second? Proposed, revised. I've got 33 pages. They're in mod chat, but they're 33 pages. Which one's 3 pages? I haven't seen a 3-page one. I've got a 36 and a 33. They're $650 for the new 3D printer. That's double. I think it's more than double what I paid for our old one. I mean, old one, it's still new. That's what I paid for a new one at Christmas. Mathis, send it to Greeners. There you go. That'd be great. And then Greeners can send it to me. Paid $1,000. See, I'm just getting in. I realize that there are much better printers than the ones we bought, but we are so happy with the one we have. RH negative, had to get Rogum shots through my pregnancy. Oh, that's not fun. What order are we reading? Well, we talked a little bit about the Hannah Payne trial. Hannah Payne was a young woman who ended up seeing like a hit-and-run driver pulling away, chased the driver against the advice of 911 to get the tags, ended up pulling up next to the driver and interacting with him. A struggle ensued. She pulled her legally carried firearm, and the driver ended up getting shot and dying. And Hannah got convicted and is serving time in Georgia. It wasn't that outcome alone that put Georgia on the blacklist for me, but some of the stuff that came out about the investigation during court put Georgia on the blacklist for me.
You are banished from the state of Georgia.
Mm-hmm. Yeah. And anyway, so here we go.
So just as I told you yesterday, things continue to move along quite well.
Give us a pacing.
I think there's some belief, as we were talking about the Commonwealth's next witnesses, that their case is likely to finish up by sometime, I think, relatively early on Thursday. So things are moving along, and then there will be a defense case with some defense witnesses. Tomorrow will be a one-witness day. Who I gather to be the lead investigator in this case, Trooper Williams,
all day,
will be testifying tomorrow. There'll be a recorded interview of Miss Church played, which in and of itself is about an hour and a half that you'll be listening to. So, but I think tomorrow may be a day where you're excused at 1 o'clock. It may be even a little bit before that, depending on the length of cross-examination. If we press into the afternoon, it's just completed the testimony of Trooper Williams, and whenever that's done, you're done for the day tomorrow. They're trying to line up witnesses for the rest of the week, but I wanted to let you know that's how tomorrow looks. So that's where things stand. I want to thank you all for your time and your attention, as always, today. We're very appreciative of that. And so I'm going to excuse you with the usual cautions. Until we see each other again, don't discuss the substance of this case with anyone, including among yourselves. And please don't allow yourselves to see, read, hear, or overhear anything from any outside source about any aspect of this case. Thank you so much, folks. You're excused until tomorrow morning. Oh, one last thing. We will be dealing with a few issues having to do with Trooper Williams' testimony, and we're going to discuss a couple right now. Those discussions may extend a little bit into tomorrow morning, so it's likely that we'll be starting around 9:30 tomorrow morning, just as we did this morning. When I say start at 9:30, I mean from when you come into the courtroom. We're usually here before then. So if you want to alter your plans accordingly, I think you can count on that it will be probably about 9:30 when you're coming into the courtroom tomorrow. So thank you. Now, with that, you may be excused.
All rise.
We're going to remain in session. Yeah.
The only thing that changed.
Put it back in session, maybe seated, silence all cell phones.
So understanding that Trooper Williams is testifying tomorrow, and I gather that he is the witness through whom the defense would seek to admit the text messages between Ms. Church and Mr. Fowler.
Oh, that's going to be spicy.
I think we should have a discussion about those.
It's going to be spicy today.
We can discuss anything else either now or tomorrow morning, including proposed redactions or disputes about the second recorded interview. But with respect to the texts, let me make a few observations, unless the council has something. Have they come to some agreement now?
We have not come to any agreement yet.
All right. Well, let me make a few observations to set up our discussion of the texts. I've reviewed the texts between the defendant and Mr. Fowler, which are, as far as I can tell, over a 10-day period leading up to Mr. Fowler's death. That is, they're from November 2nd to November 12th, I believe, of 2022. It appears, as I think the Commonwealth had indicated to me, that the majority of them are explicit sexual talk between the two correspondents. Although I can't see what links Mr. Fowler was providing to Ms. Church in these texts. I can see there's little thumbnails, photos of some kind. I can't really see what they are. But I gather from the text commentary back and forth that he was sending Ms. Church pornography clips, and that the clips involved, again, I gather from the correspondence, a number of men having sex with a woman. And the texts appear to reflect, I guess what one might say was an intense and highly sexually charged relationship between Ms. Church and Mr. Fowler in that time period in November of 2022. That being so, I can see two potential bases for admission of the texts. The first, which was the reason cited by defense counsel, is in aid of a Bowden defense. The defense contention, as I understand it, is that given that investigators had access to the texts, a review of the text should have led them to question whether the defendant was the appropriate principal suspect. I'm not exactly sure where that, according to the defense, should have led them, but that, I gather, is the gist of the Bowden contention with respect to these texts. The second basis for admission or potential admission is that the texts could be viewed as reflecting a state of mind by Ms. Church during that time period that is, I suppose one would say, certainly not homicidal with respect to Mr. Fowler. One of the things I want to bring up is that if I accept that the texts have some relevance for those two purposes, I question whether those purposes wouldn't be fully served by asking the lead investigator, that is Trooper Williams, to affirm the tenor of the text by simply having counsel describe their gist in more general and less explicit terms than the texts themselves.
Thank you, Judge.
I don't purport to know how most people would react to reading this text correspondence. But I have to imagine that there may be jurors who are somewhat appalled and disgusted by it. Not only are the texts sexually explicit and graphic, with much discussion about, at least as I can understand it, whether on a planned trip to New Hampshire, the defendant and Mr. Fowler can recreate the scenario depicted in the pornography links with multiple men having sex with Miss Church while Mr. Fowler watches. But there are many statements by both of them that could be viewed as racist, or at least as perpetuating racial stereotypes about black men. The text may be seen as highly offensive by some jurors, and I would expect maybe by nearly all of them. Mr. Scully, I ask you, have you made a reasoned strategic judgment that it would be advantageous to Ms. Church to seek to admit all of these texts rather than eliciting a description of them?
You bring up some good points.
Well, I mean, you can't read these without thinking, why in the world does the defense want the jury to get this particular portrait of Ms. Church?
Well, I guess Your Honor said it very succinctly. This shows that her state of mind during that period was not homicidal. It would be great if it was much nicer and more palatable and more mainstream and, more acceptable to many eyes, I think. And it's just not what we have. So I have to make a choice. Do I want the non-homicidal state of mind text or not? And the choice is we do.
Okay, I mean, I just wanted to make sure. I had no doubt that you and Mr. Norkunis have thought about this, discussed it fully with Ms. Church, and I want the record to reflect that because there's certainly a potential downside to this. It certainly doesn't seem to cast either of the correspondence in a light that's going to that is I think flattering in the eyes of most people who would be reading them. This is in any event, I just want the record to reflect that you understand how these can be viewed by jurors, and there's a reason why you want these texts in. This is so. You've told me that you have, and you might have preferred them to be written in a different way, but they are what they are, and you think you need them. Is that a fair statement?
That's a fair statement. That said, if the court is inclined to let that universe of text in.
Well, I will tell you right now, I'm not letting any text in once the correspondence is stopped. It appears to me, and you can correct me if I'm wrong, but the very last text by Mr. Fowler is on page 5280 at 5:27 a.m. And so it appears that he is texting, and right up to that last text, he's still texting basically about these sexual matters. But that's just hours before the ambulance is coming. Am I correct?
Right.
But there's no texts after that one, and so every text by Miss Church thereafter is not a correspondence. It's not a back and forth. It's a soliloquy by her at a time when she knows she's not getting a response, and I don't see a basis for admitting those.
So what I would say, Judge, is we have.
And I haven't made a ruling yet because I want to hear from the Commonwealth, but I've told you I think there's some potential relevance for the texts up through that last one by Mr. Fowler at 5:27 a.m., and I'll hear from the Commonwealth after we've had our discussion.
So what the defense is thinking is we wanted to present the court with the universe of the text we're looking at, and you can now see, some of the problems we have. What I would like to do is separate them into two sections now. The first section up until the last text of Leroy Fowler that he replies to. That's section 1.
Okay.
And we would seek those in. My plan would be, I think, to follow the court's suggestion, ask Trooper Williams a little bit generally about the nature of those texts. There was nothing in them homicidal, something like that, to show the nature of it. And then to just offer it as an exhibit that the jury can look at later.
Without eliciting the specifics in any of the texts.
Shock and awe that it'll have.
Okay.
The other thing I'm thinking about that is now that, if the court rules that universe is admissible, what we would probably do is now take a second look at culling out some that we think are just unnecessary, redundant, inflammatory, so that we have a smaller subset, which I didn't want to do to start with. I wanted the court to see the full subset. But if that goes from 1,000 text messages to 500, it probably cover, or if that's the ratio, right? But probably the point is made, the state of mind point is made. But I didn't want to withhold anything from the court when you're making that ruling. So we would take a second look at now narrowing that set of text messages.
All right, I understand.
And then I could address sort of the second text message, which I agree stand on different footing.
All right. Well, first let's talk about the first section. Let me just hear from the Commonwealth on the texts up through Mr. Fowler's last text. Mr. Camellia, you've heard my analysis of the potential relevance. And
yes. Well, 2 points that I want to make, Judge. First, with regard to access, which you had mentioned. So the search warrant that the Commonwealth obtained for Ms. Church's phone allowed the Commonwealth to look at text messages between November 8 and November 12. So when I had shown these text messages to Sergeant Williams on Friday when they were provided to us, by the defense, Trooper Williams rightly pointed out to me that the ones from before the 8th were ones that he's never looked at because they were outside of the scope of the search warrant authorization. We were not allowed to look at text messages before the 8th unless they had a certain keyword in them, like poison or murder or whatever.
So the ones from the second, November 2nd to November 8th were not text messages that he was able to review.
Based on the search warrant, exactly.
So for purposes of the Bowden component of the analysis, at least a portion of these texts don't really.
They don't have, he didn't look at them, so they don't have any reflection on Bowden for.
Because he couldn't. It's not something he should have done and couldn't. Therefore, it was a fault in the investigation. He was following the parameters of the authorized search.
Exactly.
All right. I accept that. I think. All right. That's the Bowden component. There is the state of mind portion of it.
Yes. And while.
Judge, it's my birthday tomorrow. Do we have to do this tomorrow? Make a better argument, prosecution.
I think given the nature of the relationship between these two individuals, as it has been testified to over the course of the trial, I mean, I don't know how to describe it other than sort of toxic and dysfunctional. So I don't know that them trading what can only be described as sort of vile text messages between the two of them really go to Miss Church's state of mind with regard to whether or not she was homicidal. I think it goes far more to the state of mind of Mr. Fowler about whether he wanted to have some form of sex or watch some form of sex that Miss Church was participating in. But he's the one that's sending the vast majority of these pretty disgusting text messages. So one, I think it's an attempt to sort of smear Mr. Fowler because I don't think it makes Miss Church look as bad as it does Mr. Fowler. I'm not going to say she's not involved or engaged back in these text messages, but for the most part, these are coming from him, not from her. So I think it goes to his state of mind. Her state of mind, I mean, she's agreeing, but I think it's a lot less relevant to her state of mind. And again, I think it goes to their state of mind about whether or not they were in a toxic and kind of vile relationship, but whether or not it goes to whether or not she was going to wanted to kill him on November 11th, I don't really see that it provides much support for that proposition.
Well, what I really ask myself is not whether your interpretation, which is a reasonable one, is the right one. It's whether a reasonable jury reading these texts could draw an inference that at that particular point, leading right up to hours before the ambulance arrives to care for Mr. Fowler, Miss Church was interacting with Mr. Fowler in a way that would be contrary to a contention that she was affirmatively trying to kill him. And I make the determination that the jury could. It's not the only interpretation, and that's what argument's for.
They're coming in.
You've made your points as to why you think that this speaks much more about Mr. Fowler than Miss Church. And I've also considered the 403 concerns about how this makes Mr. Fowler look, the decedent in this case. I'm very sensitive to the idea of whether this is just a smear of him, because it doesn't, I don't think make either party to the texts look particularly good in the eyes of a jury. Yet I also understand that these are private texts between two consenting adults, and what they choose to say to each other when they think only the two of them are seeing these texts is really between the two of them. Now it turns out that
guys, remember,
a lot more people are seeing these now.
All your texts can be read in
I try
court.
to bear in mind that the way they struck me is not necessarily the way they'll strike everybody else. And Miss Church and Mr. Fowler had every right, if they wished, to interact with each other in this particular manner. But I do think that, on balance, I don't find that the probativity in terms of Miss Church's state of mind at a crucial time period is outweighed by the danger that the jury will really think ill of Mr. Fowler, the decedent in this case. I think there's a construction of the texts that would support a defense argument that Miss Church was engaged in what I refer to as a highly charged relationship with Mr. Fowler's at that point, and that may be contrary to a contention that she had a specific intent to kill him at that time.
If that's the case, Judge, if that's the court's ruling, I don't want the defense to be able to cherry pick
She wants all of
the
it.
ones that
Yeah, they want all.
make
This
Ms.
is the
Fowler
right
look the worst,
move.
and I want them all in. If we're going to put them in, I want them all.
Well, and
Because
so
that
that's
makes them
fine.
into
Mr. Scully
racism
can
stuff.
engage in that exercise, but it may be that I agree with you. If some are coming in, they should get, it's a relatively short period of time. They should see them all, but I will tell you that I won't preclude him from telling me if he thinks there are some that but that's my ruling with respect, I'm sorry, with respect to the text up to Mr. Fowler's text on page 5280 at 5:27 a.m. Now, with respect to Ms. Church's unresponded to texts thereafter, Mr. Scully, what is it you wish to tell me about those?
That was the right move by the prosecution.
Well, Mr. Fowler was in the hospital.
I'll explain it in a second.
Again, I think the primary, it's the same two basic grounds. The primary reason that we would ask that they be admitted, or we do ask that they be admitted, is the state of mind of Ms. Church, which was called into question, primarily by the witness Tammy Carbone, and secondarily by the witness Leroy Fowler III, who Tammy Carbone came up with her interpretation of Judy's silence being malicious. And coincidentally, what Judy does in those texts, especially at the beginning, is really explain so that Leroy can someday wake up and she has defended herself and can explain, how she was with him and by him and tracking him, and how she waited to notify the family, why she waited to notify the family, and so forth. So again, she has no idea, obviously, at this time, that these are going to be seized or searched. They're not statements, made in furtherance of a self-interest. These are just her communications to the guy that she loves, who's now unconscious in a hospital bed. And she has received information that has made her think he's going to come through and prevail. And she wanted to have this explanation waiting for him.
Sorry about the drink. I mean, what's in the text?
For the same reason, those are admissible to the extent that they fall inside certainly inside the search warrant ambit. Where I think there's still a Bowden issue is, as the prosecution is developing this very specific theory that law enforcement is developing, that she wanted to kill Leroy Fowler out of revenge for his relationship with Barbara Randall. I think these fly right in the face of that motive that they opened on. And that's my summary of how the motive that they gave at the beginning of the case. And that drove this whole prosecution. So I think that they should come in still, and under Bowden, the reason I think they should come in is that Trooper Williams gets his search warrant. It allows a certain search of the phone. They should have looked at all these text messages in this area that they had access to, and then they should have seen which way those are going, which should have led them to look for more messages outside those narrower parameters. That they had the messages, I think, from the 8th to the 11th, and they saw or should have seen what was being said between these two individuals, and that should have led them to take a look at, well, what happens, on the next several days, and what had happened on the few days before them. So I still think there's a live Bowden issue there.
I don't quite understand what you think a review of these texts should have led the police to do differently. The basic Bowden contention that they had access to some information that may, at least in your theory, undercut the Commonwealth's theory of a motive on Miss Church's part, I gather. But what you think the police should have done differently if they were fully comprehending your interpretation of these texts is what? What should they have done?
Well, number one, they could have presented them to the grand jury. Number two, they could have.
But presenting to the grand jury for what purpose? Again, I told you we haven't gotten back to this issue, but I don't see litigating before this jury the grand jury presentation. We're not. This isn't an Odell motion, so they're not going to be hearing claims that the grand jury was misled or was given incomplete information. The indictment stands as a charge, and we're not relitigating the indictment process here. So what, in terms of investigation, do you believe should have been done that these texts would have led the police to do?
Well, first of all, I think the stronger argument is under the state of mind. Okay. Second of all, under a Bowden or a bias issue, which I think are similar in this case. Okay. But in particular, there's a bias issue that what the police did is they didn't look at any other alternatives. They zeroed in on Judy. So they did the interviews, the interview with her on the sidewalk. They did the interviews with the Fowler side of the witnesses, the 4 witnesses at Mr. Eaton's house. Right. 2 days later, they interviewed Barbara Randall, and that was it for interviews. They didn't do anything else after that in terms of investigating which way the case could have gone. Leroy Fowler's phone at that time had not been opened. They had it. They would have seen all this information because this was what was on it from Judy's phone. They also had access to Leroy's phone, all the text messages that they got because they got Barbara Randall's phone was presented right after her November 16th interview. And if they opened that and they saw it, they would have seen all of the abuse and emotional abuse and physical abuse that was documented on that phone. And I think they should have taken that all into consideration in bringing the charges against Judy Church, but they didn't. So I do think they had developed, all along, it's been our theory that they jumped to the conclusion that Judy must have done it right away, partially based on some Google searches that Trooper Williams did. The lab work wasn't back at that time. The time they were arresting her, forget the grand jury, the time they arrest her, the laboratory work from NMS isn't even back. So we know at that time, I believe they had evidence at that time that Judy Church was arrested that he had died from ethylene glycol poisoning. They had a phone conversation with the medical examiner is what I think. I don't think they had an autopsy report at that time. They had seized these 2 items from her home, one being Powerade, one being the Rain-X. Okay? At that time, they thought, we've got it. 1 + 1 = 2. There it is. But they hadn't even done the laboratory testing. So there was not even a laboratory test yet that said that even the Powerade contained ethylene glycol. Right? And they had the Rain-X, but they hadn't, it says it contains a bittering agent, but they had done nothing with that. And then most importantly, at that point, what they also hadn't learned is that the Rain-X, which was originally thought to be the likely source of the poisoning, is scientifically excluded as the source because there's such a small amount of ethylene glycol by percentage in the Rain-X and such a large amount by percentage in the fluid from the Powerade that it can't be from each other. And yet, they didn't pause 1 second and consider anything else.
So, I understand the argument is, generally speaking, you contend that there was a rush to judgment on imperfect and incomplete information, and that's something you're going to be permitted to pursue. I have no doubt you're going to be asking about, the NMS testing and why no test for bittering agent and all those sorts of things. But what I'm focused on right now is whether these texts after Mr. Fowler goes off to the hospital should come in. I'm going to go back and look at these, each of these. I will tell you, though, that I start with a disinclination because
Self-serving
these
hearsay.
texts are being sent by Miss Church after Mr. Fowler has gone off to the hospital with what we ultimately know or come to know was lethal ethylene glycol poisoning. It's like somebody, a defendant, just deciding in the midst of the events leading up to an arrest to take out a recorder and start putting down all their thoughts and then say, I want the jury to hear these things. That's what this is like to me.
Hearsay.
Mr. Fowler's gone off to the hospital. He's in dire straits. We've seen what he looked like on those videos that Miss Church took. And she's taking this time to put all these things down in these texts that she knows he's not going to be responding to. And many of them would strike an objective observer as self-serving statements by her. And so I have a disinclination to say, oh, these come in as valid state of mind statements by Ms. Church. I'm going to look them over, and we can have a more focused discussion once I've had an opportunity to do that. And so we'll table that discussion until then. I remind you, Mr. Scully, of what I'm sure you already know, but Mr. Camilio made reference to this way back when we started discussing Bowdoin, but there is pretty broad leeway given in Bowdoin rebuttal. And so when you're asking questions of Trooper Williams, why not this, why not that, why he's going to be permitted to give his explanation for why the focus was on Miss Church and not on other people, including who had access to the Powerade bottle and all these other things.
Right, I recognize that, but the Bowdoin in this case is very specific too. We're not challenging specifically under Bowdoin grounds what happened, and basically until they have all the evidence that they've seized, the phone seized, all the evidence from the search warrant seized, right?
You don't get to
now
pick
the
and choose
Bowdoin
that.
defense is what do they do with the lab? It's all laboratory stuff, right? The rush to judgment is a bias issue, not a specifically Bowdoin issue. So when we're talking about your interview with 4 people and maybe rushing to judgment, that's not necessarily Bowdoin. So what did they not do? What would they have done differently, now that they know we're challenging the lab stuff?
What is a bias issue? I know what bias is when there's a claim that a particular witness is biased such that the jury shouldn't credit what the witness is saying. But you're talking more generally speaking of sort of generally an overarching antecedent bias against Ms. Church. But ultimately, this case rises or falls on the evidence that's presented in this courtroom. So what's the bias issue you're talking about?
Well, it strikes me that that interview on November 14th with the family members at William Eaton's house, that those people got together and decided to tell police what they thought that might connect Judy Church to this case. And essentially what the police did is try to solve the whole case in one meeting. That's it. That's basically there it is. We got the whole answer right here. They interviewed Barbara Randall after that, and John Haywood pops up out of the blue 2 years later. So he's not really part of the investigation. He just pops up in the middle of the litigation, I think after the motion to dismiss case was heard. And there was some media on it, but setting him aside. So I think that's the bias. It's not racial bias. It's not necessarily gender bias, although you wonder. It's that, they wanted to resolve this case quickly without necessarily doing any more work. And I think that's the bias that developed, the law enforcement bias.
Well, you calling it bias, I think that is a form of Bowdoin. It's still a claim that it was a rush to justice with an incomplete and imperfect investigation for various reasons that you wish to highlight for the jury, and you're permitted to do so. But anyway, I don't think we need to belabor that.
Yeah, right. What I really don't think we're opening the door to is anything that was excluded in terms of when she lawfully said, I don't want to let you search my house.
No, you are not opening the door. Someone standing on their constitutional rights, that door doesn't really get opened. So what I'm talking about is if the questions is asked, a trooper's generally permitted to respond why they thought that the evidence was strongly leading them in one direction. In this case, it may be whatever Trooper Williams may choose to say, but I would imagine the fact that Mr. Fowler's living with Miss Church, there's a bottle found in the recycling that has this liquid that ultimately they think is the murder substance. Nobody else is there. She's the one who has access to it. All those sorts of things. Those are generally fair rebuttal to a contention that they should have been looking elsewhere or doing other things.
Fair enough. We're on notice. I don't know where the Commonwealth's going to go, but my biggest
I don't either.
Constitutional issue.
No, I don't. Who's handling Trooper Williams?
I am.
Yeah, we're not talking about any belief on your part the door's been open to say Miss Church wouldn't let you search her house without a warrant, would she?
I can't imagine that door being opened.
Nor can I.
But I mean, I guess if it is, we'll come to sidebar first. But I do expect just about everything else that has been sort of discussed in motions in limine and things that I obviously chose not to put in because it is, it might have been hearsay or whatever. That stuff is all fair game on Bowdoin. And I do expect all of those statements that are attributed to Ms. Church by various witnesses or attributed to Mr. Fowler, by various witnesses about what Ms. Church said. I do expect all of that to be Bowdoin-related rebuttal. So I made that pretty clear in the motions in limine last week, and I think the court is fully aware of that. So I do expect that as far as I'm concerned at this point, the Bowdoin door has been kicked as wide open as possible based on the opening and the cross-examinations of various witnesses here, both in terms of what the police knew prior to Mr. Fowler's death or what they did at the lab after. This is the entire defense has been Bowdoin and with hints of third-party culprit. So I'm not looking to put in anything that is a constitutional right for Ms. Church. I'm not, I don't expect to say, oh, you had a lawyer, and you stopped talking. Obviously I'm not doing that, but everything else is fair game.
All right. Last thing, Mr. Camilio, just before I recess and take a look at those texts that came after Mr. Fowler went off to the hospital, is there anything you want me to think about in reading those texts?
Well, yeah, the court made a point the other day that, we used to have a state of mind exception that basically swallowed all the other hearsay exceptions, and that's no longer the case. And this is classic denial by the defendant, which the SJC has told us is not admissible. This is a statement from the defendant: I did not commit the crime. Right? I mean, that's the summary of what these 25 or 30 text messages are. And to allow a defendant to, as you said, either write it all down or do a taped deposition or a taped statement where they explain all the reasons why they're not guilty. I mean, if they want to put that stuff in, they should got to testify.
Well, I think you're conflating two separate things a little bit in terms of what the SJC says. When they talk about exculpatory denials being inadmissible, first of all, I'll say it, I've said it umpteen times, I don't understand why the SJC says that. In the context of an interview, it seems, and defense usually don't stand on that particular objection. Context of an interview where there may be incriminating statements, generally speaking, I think it's appropriate for the jury to hear the denials as well to understand the full tenor. But what I was making reference to the other day is the fact that the SJC has made clear that the state of mind exception does not apply where you have to believe the truth of the matter asserted in the statement in order for it to have relevance to the declarant state of mind.
I do think that is exactly what
and that may indeed be what's going on here. And so when that's the case, the state of mind exception does not apply because it's essentially not a hearsay exception. It's the truth of the matter. So I will be, that's why I want to go back and look at the text.
The one other issue that we really do need to deal with today and we can't do in the morning
Oh,
is
okay.
the interview of Mr. Miss Church.
Oh, you need to make the redactions. Okay.
And there are two that we
Mo,
are sort of in
welcome.
dispute on. One, there is some
Thank you very much for
discussion.
the raid.
Trooper Williams or
Low and
Detective
deep
Ernie
end.
asks Miss Church if she would take a polygraph. There's some discussion back and forth about that. She eventually says yes, but not today. A week later, we get a letter from a lawyer saying, don't talk to my client. So, there's no chance of doing a polygraph. I think getting into any of the polygraph is going to get into the reason why it didn't happen is because we got this letter from a lawyer that said, don't talk to my client. I think that's just not worth getting into. I don't see any relevance to the polygraph where she says, yes, I'll do it, but not today. It just seems like a nightmare to litigate that whole thing. I asked that the court take that out of the statement.
I don't have a copy of the statement.
I can give.
I
thought you did. I
Did I?
apologize, Judge.
I have a transcript of the statement.
I thought you had been given one,
gee.
but it might have been
Thank
only
you so much.
interview number one.
The only thing I got was a marked up interview 1. I never got a marked up interview 2, to my knowledge.
Right, you have the, we have C for ID, which was.
Is that number one?
I don't think that's it.
This is Tammy Carbone.
Sorry.
I'll provide it.
Thank you.
And Judge, the other issue.
Sure. Can we keep this, Mr. Camilio?
Yeah, I'll print another copy.
All right.
Thank you. This will be, him.
And then and so that takes place on page, actually, it's that time, right?
There were agreements that we had that were already taken out. I can provide the court the highlighted portion that I flagged yesterday of the two things that I thought we had missed that should come out. I think those are the things that are in dispute. I believe this is an agreement to the first part.
I'm sorry, I was looking at this transcript on the interview, so I'm.
So Judge, it's at, starts at 1:17:52. It's towards the end, obviously.
11752.
Yep.
Is this one of the ones you're talking about, Ms. Strasnick?
This is, it's one of the two that we're, I guess, not in agreement about, Judge.
This is the statement, I did not do it?
No, this is would you do a polygraph?
Oh, would you do the polygraph?
At 1 hour, 17 minutes and 52 seconds?
Yes.
Oh, yes. Okay, now I see it. Would you do a polygraph so we could just clear you and move on to the next person? Okay, and she says yes, but of course my heart is like being yes, but yes, absolutely nothing to hide. Okay.
And then she goes on to say, I don't want to do it right now. Please don't. That's at 1:18:31.
Oh yeah, that's in there. Yeah, forgot that part.
All right, so what you are proposing redaction of what, Mr. Camilio?
I'm proposing redaction starting at would you do a polygraph up until Ms. Church says, I don't want to do it right now. Please don't.
Okay.
Which seems to convert her, yes, I'll do it, into a no, I won't. And then obviously, as I told the court, we got a letter from her lawyer at the time saying, don't talk to my client, so no more polygraph.
Okay. All right. That's one of the two. And what's the other one?
The other one is right at the end, Judge, and it is at
Got a lot of explaining to do as soon as they're done. Couple issues on the table here. Starting with the messages.
Yeah. It's at 1:34:05 to 1:34:27 in that box, and it's at the end. She says, I did not kill that man. I think I need a lawyer. This is starting to get ridiculous to me. And I think that I did not kill that man should come out because I think it's made in the context of I think I need a lawyer. And I don't think it's fair to leave the denial in without the full statement, which is I think I need a lawyer.
Why does I did not kill that man? Why do you think that's linked to I think I need a lawyer?
Well, I just think because she stops and she says, we're happy, laughing, and no, I don't. And then she says, I did not kill that man. I think I need a lawyer. I don't know how to read that without those two things being part of the same thought process of Miss Church.
So you're proposing just a redaction of, well, right now, aside from I did not kill that man, you've agreed, by agreement, I think I need a lawyer is being redacted?
Right, and pretty much everything that falls after that is a discussion about the lawyer. So
so the agreed redaction, starting with I think I need a lawyer, goes down to what?
Yeah, I think it goes all the way to the.
Is that it?
There's one block at 1:36:17 where Trooper Williams says I'm going to end says the time, says I'm going to end the interview right now.
So it's the only thing the jury hears after that is I'm going to end the interview.
Yeah, he says the time is now 5:36. I'm going to end the interview. Okay, I have my card here, which I didn't have the other day. He gives her his phone extension.
Okay.
Says they'll give her a ride back to her house.
Okay, so by agreement, there'd be a redaction from I think I need a lawyer at 1:34:27, all the way down to when Trooper Williams says the time is now 5:36. Okay.
And everything that follows after that, from 1:36:51 to the end, is also coming out.
Okay. All right. So the second dispute is about whether or not a single line gets redacted, which is I did not kill that man.
Yes.
Okay. All right. Has she not said that before during the course of the interview?
I don't know that she says it in exactly those words, but yes, she asserts her innocence at other parts of the interview.
Okay, I'm not going to require redaction of that. I don't see the reason for it. With respect to the first redaction, I don't see the reason why the jury should be hearing about the polygraph. They go back and forth. The polygraph ultimately wasn't done. The lawyer got involved. Polygraphs are not admissible. I know that doesn't mean that statements about them might not be, but I don't see why that should be in there, given that she said yes, then she said, I don't want to do it right now, and then ultimately, with a lawyer involved, she didn't do it. So I would agree to that redaction. So those are rulings I make.
And just note our objection on the polygraph, Judge.
Yeah.
I agree, it kind of cuts both ways, that she said she would do it and then sort of backed off a little bit. We viewed it as the police were basically misleading her with an offer, like daring her, trying to get her to make an admission. I think they did something similar when they suggested her fingerprints were found on antifreeze at her house earlier in the interview, and she's like, at least that's my memory, that they found antifreeze. They didn't find antifreeze. And my memory is that they said something about her fingerprints being on them. And so there was a little bit of this, sort of enticing her to see if she would admit that she did something wrong, which she adamantly denies the whole time. So we saw it as coming in on that. Just note my objection on that.
I do.
Noted.
All right. Anything further? Mr. Camillo, you look absolutely shocked and dismayed that I've made that ruling.
I guess I apologize for my lack of a poker face, Judge. I just don't understand how a denial, it's just a straight denial by the defendant that doesn't provide any context to the rest of the interview. And so I guess I'll have to go back and look at the law, but my understanding of straight denials by the defendant that don't shed any light on any other portion of the interview are not, I don't have to admit it, right?
Well, you're right, and I guess I wasn't thinking about this in terms of the doctrine of completeness, because and I don't know how much has been taken out, but where you're putting in, a substantial interview, I have to believe that there's all kinds of things that are in here that are not just the cherry-picked statements that the Commonwealth has chosen to put in, and anything that may be necessary to explain those particular statements, which the Commonwealth has a right to do.
Right.
They could put in a statement on page 1. They could put in a statement on page 10.
Exactly.
But that's one of the reasons why I ask. Is she making professions of innocence
She may,
elsewhere?
I mean, she, like I said, she never comes right out and says, I did not kill him. She does not. She never admits to having done anything, and she doesn't admit to having, killed him. Obviously she makes no admissions. Otherwise, I'd be putting those in specifically or highlighting those specifically. But I guess my feeling and my understanding of the law is the Commonwealth can put in whatever portion of the statement it wants to. The defendant can only put in statements of the defendant that are subject to the rule of completeness. That statement, in my view, is not subject to the rule of completeness. So
You're right. You're right. It's not necessary. I'm looking at what's immediately coming before it, which is some discussions about.
Is he going to reverse his decision?
How is she coping with him leaving and going to Barbara's? And then she says she gets upset. I don't do anything about it. He comes home and he has little ways of making it up, and we're happy and laughing and no. And then she adds, I did not kill that man. So basically what you're telling me is you're offering the first part of that, and that the I did not kill that man is not explaining anything about what she's just said that you are offering.
Correct.
All right. So now we're focused more on the doctrine of completeness and what the Commonwealth is choosing to put in. It's just choosing to put in a lot of this, but Mr. Scully, why is that not correct? That statement doesn't shed any light on the statement right before it that the Commonwealth is choosing to put in.
I think it does in context that what Judy Church has been faced with is a series of accusations and an unfolding amount of evidence that they're disclosing to her, some of which is not true, including that they found antifreeze at her house. And then they spring these notebooks, which they've just recovered in the search, on her. And her response to this cumulative interview is to say, I did not kill that man. And it's the first time she says so specifically, because it's the first time after all of these suggestions that she has done something wrong and that the investigation is focusing on her and that evidence is building against her. This is her response to that. It's not to just one sentence before it. It's to everything that came before. There was also the sidewalk interview in the background. But really, the building momentum here of the police interview into an accusation. And I think it's unfair because that's how it reads when you see it. And she would be expected to make a response at this point.
Well, she
says, I did not kill this man.
That's not an expected response to anything that's under discussion right then and there, and it doesn't shed light on anything that I see is immediately before it. I don't have the benefit of simply saying, "Let me go through all this again and I'll finalize my decision," because the thing has to be edited so it's ready to go first thing tomorrow morning. I understand your argument, Mr. Scully, and I know that I'm reversing myself here, but that's why I always try to be open-minded about such things. But I don't see that statement as shedding any particular light on anything that's said right before it. And if she makes no overt admissions to anything, I take it, in this interview, Mr. Camilio?
No, Judge, she does not.
So it's not like it's needed to understand that she may have said, I did something, and then she's taking it back. She's made no admissions to anything in particular, so it's really just a freestanding assertion of innocence, which doesn't really shed light on anything else. So, no, I think on further reflection that the Commonwealth's not required to put it in, and I don't think that statement is necessary for the jury to fairly consider the statements that are being put in. So that too may be redacted. That's it for today.
That's
Thank
it.
you for
We're done.
I do.
One more thing to add.
No, my goodness.
Okay.
Sorry to everybody. As a court, so note our objection to the court's ruling.
Noted.
As the court's going back to consider now the potential admissibility of the ongoing text messages that Judy sent to Leroy when he was at the hospital, one other thing that I just want to put on the court's radar screen is that in assessing her state of mind, take a look at her text messages that she had been sending all that evening and that Leroy had been sending to her. Because what it shows is that Leroy had excellent dexterity and a focused chain of thought process all night long. Okay, we know on Thursday he was good because William Meaton saw him and talked to him. And then all night long, he's texting her, he's sending her links, he's proposing scenario. There's a lot of dexterity involved with that. Clarity of thought and dexterity, hand-eye coordination, all being sent to Judy, which goes to her belief that he's going to be okay, which is what she's basically under the impression of when she is cut off from being in the medical care, which goes against the idea, I would submit, that these are self-serving statements and show that they are, true state of mind exception statements.
Well, anybody who observed what Miss Church observed firsthand and videotaped and was shown to the jury would understand that Mr. Fowler was in pretty dire straits when he went off to the hospital. Something was grievously wrong. So he may have been dexterous in his texting up to 5:24 in the morning, but by 8 a.m. he was in serious and dire medical condition. So that was the reality at the time of those texts. But I'll read over the texts and we'll have that discussion. We'll be recessed till tomorrow.
All rise.
All rise. All right. 4:58 on the cough counter. Takes us to the end of the day there, but we have some things to talk about. First, about tomorrow. The text messages that the judge has ruled should come in because I guess they're more probative than prejudicial. They're spicy, like FetLife spicy. I don't know if that website is particularly the one mentioned. That's just one from a previous trial. That's why it comes to mind. We are hoping, because it's my birthday tomorrow, that they're just going to summarize generally the tone of the messages with the officer and not try to play the blur the image on the screen game, which could get us in trouble with YouTube. So if this view that you see right now comes up during tomorrow's trial, you'll still hear what's going on. But just know I'm just covering my own, right? I'm looking out for number one here to make sure that we can still do what we do every day. There's going to be some spice. Hopefully it won't be terrible. I just don't know how much is coming in. Now, the state argued against this strongly. Defense says these are important because it shows that Judy and the victim were in a great relationship. Well, they were in a relationship, right? But we know that it wasn't great because it was back and forth between the two people, and there was maybe three. I don't know. It had some issues. The defense choosing to put this in, saying we think it's better that the jury sees Judy in this light than, not knowing that these are the texts that happened right, leading up to hours before the victim passed. That's a bold move because I think it could be just as reasonable for the jury to say, wow, Leroy proposes, hey, I've got an idea. Let's do this to Judy. And that could have been the straw that broke the camel's back for Judy. And she's like, sure, yeah, let's go ahead with that plan. Let me get you a drink. Let's toast to that. Right? Is that not another way the jury could take that same thing?
I'm not a camel.
Anyway, we'll see how that goes. The officer comes in tomorrow. Her text messages, I'm with the judge on this. After he's going to the hospital, assuming, if we look at this in the light like she's accused of poisoning him, assuming she's poisoned him and then he goes to the hospital, it would be wrong to let her type out her, I'm not a killer, I didn't do anything wrong, and these are all going to be read in court so you guys can see this because I said it before I was arrested, right? It would be wrong for that to come in. But with the presumption of innocence that she is shrouded in, innocent unless proven guilty, would it be wrong to keep them out? I think the hearsay argument's going to be had a little bit, and I'm curious what the judge rules on this one. I think keeping them out might be the right answer, because if nothing else, it's a self-serving statement outside of court. Period. End of story. So I think her text to Leroy,
when we started 110 years ago,
after Leroy was no longer checking his text messages because of his health condition, I think that stays out. Now, we've got a couple other things. First of all, the Rome, Georgia courthouse is burning down. And I say that literally. It's on fire. It's on fire. Rome, Georgia, you had a historic courthouse. It is burned down. Everyone was able to evacuate. It was historic. It was under renovation. They don't know what started the fire. There's a whole bunch of other rumors which have not been substantiated. And but the flames are real. You can go all over Twitter and see the flames shooting out the top of the building. It's very sad to see a historic building go. I know Notre Dame, when it burned, was sad as well. This obviously doesn't have nearly the same history as the great cathedral over in Europe, but anyway. Can you have a digital post-it to cover the text if they're too spicy? I won't see the texts until you do, is the only problem. I don't have a delay from when I see them to when you see them. And I could set it up so there is one, but currently I don't have that. Let's see, the other thing. What's the other thing? I've got some reading to do, some light reading. Our courthouse is burned down twice as my quote projects. They just don't get the message. You need Greener's lightning fast reflexes. Yeah. Tomorrow's gonna be interesting. I hope for my birthday they don't ruin it for us, right? Don't ruin it for everybody. We came to watch court. Honestly, like Greener said, if this turns out to be spicier than the Afro Man trial, which we did not watch because it was too spicy. Yeah. All right. Now, on to the reading. Let's get to the reading, shall we? Hang on one second. We have 3 pages of reading in the Georgia, or the Payne versus Georgia appeal. If I can find it here. Where's it at? Right there. Let's go full screen. We're reading it in Acrobat itself, which is not a sponsor. Go Adobe. Go to 5. We have some reading to do here. Can I zoom in at all? Do we have an embiggen button? Is that big enough? That's big enough. All right, this is Supreme Court of Georgia. March 20th is the date. Came in just on Friday, just got filed. The Honorable Supreme Court met pursuant to adjournment. The following order was passed. Hannah Renee Payne versus the state. Counsel for the state is hereby ordered.
It's bigger than me. It's bigger than all of us.
I see you, Laura. Counsel for the state is hereby ordered to file a supplemental brief within 10 days attaching exhibits the following items. 1, a sworn affidavit from counsel providing the following information. A complete explanation based on all information within her possession as to how the September 12th, 2025 order of the trial court denying the motion for a new trial, and which reflects that counsel prepared that order, came to include the following citations. Reynolds v. State, the case is cited at pages 10 and 22, but does not exist, and proposition for which is cited is obviously wrong. Harbuck v. State, which is cited at page 11, but does not exist. Jones v. State, which is cited at page 11, but does not exist. Hughes v. State, cited at page 11, but does not exist. Manzano v. State, which is quoted at page 13, but the quotation does not exist. Durden v. State, which is quoted at page 13, but the quotation does not exist. Lang v. State, the case is quoted at page 13, but the quotation does not exist. Nelson v. State, where it's quoted at page 26, but does not support the proposition for which it is cited. Davis v. State, where the case is quoted at page 26, but does not support the proposition for which it is cited. A complete explanation based on all information within her possession as to how the state's reply brief to the defendant's amended motion for a new trial filed May 2nd, 2025, came to include at least some of the citations included in 1A. B, a complete explanation based on all information, or C now, sorry. A complete explanation based on all information within her possession as to how counsel came to file state's reply brief to a defendant's amended motion for a new trial filed August 8th, 2025, and which appears to have removed at least some of the citations in A1, in 1A. D, a complete explanation based on all information within her possession as to how the state supplemental brief filed August 19th, 2025 came to include at least some of the citations included in 1A. They're saying, show your work. You sent us a filing to the Supreme Court, an appellate level filing. Okay, this should be top of your game. You're going to a row of judges are going to be reading this, right? This should be your best work, your strongest argument. And you cited slop that AI hallucinated into being, both in cases and in citations. And you just stamped it and sent it off. So explain how it got there. Explain how it stayed there. Identify whether any other citations in any of those filings are to cases that do not exist or involve non-existent quotations, and if so, provide a complete explanation as to how and why that happened, and any other information counsel believes is relevant to this issue. This is the most show cause of show cause requests I've ever heard. How did this get here, state? How did you get to this point where you filed an AI-generated filing in a Supreme Court appellate? Oh, okay. At least they got on him. 2, the proposed order submitted to the trial, as well as a copy of all communication between counsel and the trial court regarding the proposed order, including but not limited to any request for the proposed order and the submission of the proposed order. All the justices concur, except Warren PJ, because he was not participating. Okay, had he been participating, he would have concurred as well, and that's signed by the Supreme Court, State of Georgia. Somebody might lose their job over this, and maybe even their bar license. This is no joke. This is something that I think the Supreme Court in Georgia is going to deal with quite firmly. So Hannah Payne, as she's appealing her conviction, tries to appeal to the Supreme Court, and the response from the state is AI slop. Unfortunately for Hannah, the state's providing slop does not necessarily mean that Hannah gets a new trial. Does not automatically mean reversal. But it could lean that direction. So we'll see what happens. I can't wait for the responses. Is the tone of this order stern enough? Ask me if you want any changes. Yeah. She's serving life with the possibility of parole, right? Also, the legal argument you claim is obviously wrong. Oh, my goodness. I don't know who wrote that, but the lady who did, maybe we'll pull that up tomorrow. The lady who made this motion was arguing in front of the Supreme Court justice. Dude, he's like, have you read what you sent us? It's got all these citations, which are just BS. They're fake. It's not like, oh, you made a mistake and you cited the wrong case. You know, you cited Miranda, okay, and Miranda doesn't apply here because of this situation. It should actually be a Terry case. It's not like that. No, it's you literally fabricated out of whole cloth case law which has never existed, which has never happened. You cited it in proper APA format or whatever the lawyers do. I don't know. I'm really, really bad at writing papers. You cited it properly with the citations and everything. The only problem is that address does not exist. It didn't happen. Ever. And you base your argument on it. That's bad. She was bad. She wasn't even answering the judge's questions. She's like, oh, sorry, judge. I wrote it. I wrote my original one, and I know it got edited. Those dang editors, they'll get you every time. They said the original had that. She's like, if you point out exactly where, and I'll get you a supplement. We'll fix it. Clearly a typo. A Scrivener's error has occurred. Somebody was reaching for the E button and they hit the D instead. No, it's complete crap. It is crap in the filing. And she submitted it. So yeah, she might.
You're comparing apples and orangutans.
Yes, she might be. Motion for takes EV Baxby. Takes EV Baxby is coming for sure. All right, so that was crazy that no one caught it until that level. Somebody read it. It was like, yeah, it looks good to me. And they want everything. They want all the communications, everything that happened, everybody that touched it, what was edited out. Tell me. I want the notes from the meeting where you're all sat around the table and say, should we keep that in or not? Oh, we'll take that one out. Okay, we'll take it out. We want those notes. We want the minutes. Tell us who was there. Who said, yeah, all in favor? Aye. Tell us everything that went into this decision. So, Kelsey, member for 2 months as an attorney. Thank you, Kelsey. Awesome place to be a member. Thanks, Recovery Addict and mods. Thank you very much. Absolutely amazing. All right, let's see. Must have been a ghostwriter. Yes. If I just went on Fiverr and I paid some guy $6 and he made this for me. Yeah, I don't know what she did. I want to find out. I think she has to say. Okay, at some point you've got to own up to the truth, and her saying I made a typo. No, if you made a typo, tell us what you meant to type. I'll give you a hint. It's not there either. So yeah, it's an honest mistake. It could have happened to anybody. Judge, Your Honor. Some days we just put in a little too much work. We get tired. Our eyelids get a little heavy, and we're like, let me just crank this one out. I can push through, Judge. I can finish this briefing and get it ready. And I was doing that, and I was thinking back to law school, and it just all flooded back to me. And I was like, yeah, I'm on fire. I'm on a roll. No, you were thinking with Grok or Chat GPT, and copy paste, print. That's what you did. Copy paste, print. What's wrong? Should I have not done that? Well, probably. Mathis, big shout out. Thank you very much for the heads up on this motion that came out, or this ruling by the Supreme Court. Motion to check their LSAT scores. Oh man. Good times. Is there anything else we need to cover tonight that we haven't before? We've got the Rome, Georgia courthouse on fire. I guess any cases that were scheduled to be there might be delayed a little bit while we air the building out a little bit and maybe hang some new drywall. Then we have a spicy tomorrow. It's my birthday tomorrow. I've asked for my family to sing to me, so they're going to come in and join me just off camera right over here. I have to set up a microphone so you can hear them. So I'll get that part done. That's my job. I think that's it. Politely request for Kelsey Fitzsimmons on replay when it's done. Laura, I'm tempted. I have wanted to follow that one. It just, schedule-wise, was the only reason we weren't there. I hate picking up a trial and then jumping in the middle. Well, it's not just that I hate it. You guys hate it, and I get tons of flack every time I bail on a trial early. I try not to do that unless we absolutely have to. For that reason, we're sticking this one through, even though it's going off the rails a little bit. How old are you going to be? 2. I'm going to be 2, old Goals Travel. Thank you for asking. This is my last year in my 40s. Can you believe it? I'm going to be 49 tomorrow. So, or 29, excuse me. 29 again for like the 20th year. I'll be 29. We will sing to everyone who has a birthday tomorrow as well. I think there are a couple other people who share it with me, and thank you. I appreciate you sharing so nicely. I remember 49. Oh, those were the days, right? Those were the days. Don't look at day over 48. Well, today you can say that. Tomorrow, not so much. Happy birthday tomorrow. Thank you. 2 years older than my son. I'm young at heart, if that helps. I'm just a kid at heart. I remember vividly finishing my chores at home and opening the front door and running and jumping off just clearing the front steps as I'm landing on the grass to run to my friend's house. That would be basically my last move if I were to do that now. It would be like tuck, roll, boom, and next thing you know, rest in peace. Yeah, I'm not that young anymore. Buffer. Oh my goodness. How long has chat not been on the screen again? Well, you could see it right here. Does that not count? I'm sorry. So many messages I put up. So many. You saw me clicking, right? You saw me clicking all over here. You saw me. I was clicking and I was thanking people about how amazing they were. And yeah, I'm sorry. Chat was not on screen. It's because I was using this screen to show the, yeah, squinting at the screen. At least it's in focus this time. All right. Amber tells me you have to be over because she's doing the outro. So with the outro underway, we'll play the music. You have to redo the past 10 minutes. Let's just start over. Rewind. And you jump on the electric bike going after a kid. Hey.
Remember in the beginning when we started 110 years ago?
I remember. Those are good days. All right. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe. To go live again tomorrow morning. We have more court, and it might be spicy. Against my wishes, spicy. Not the good kind of spice either. We're talking the bad kind, the cringe kind of spice. The Banfield kind of spice. The bad spice. So hopefully we get just a tiny bit of that. Infinitesimally small portion, preferably. The stink. I'm going to call it the stank spice. A little bit of cringe. Might be tomorrow. So if that's what you're here for, we might have a little bit. I'm bracing myself. I am bracing myself. For my birthday. It's like the best the court could do on my birthday was this. I don't know. You guys have a good night. We will see you tomorrow morning. Be safe. Be happy. Have fun. And all the things. Do all the things. We'll see you tomorrow. Have a good one. Bye-bye.
Remember in the beginning when we started 110 years ago?
Thank you, sir. You're my new best friend.
It's bigger than you. It's bigger than me. It's bigger than all of us.
I think I'm about to catch a whooping.